Get into cases. Voting. Come on in. All we're doing is this one motion all day, pretty much. Nothing's happening. And I'm having trouble with CCAP. It's not working right. What's going on here? Okay, people's not available. It's not good. Maybe. Can't get in. Here we go. Oh, our door's open. Right at 8. Okay. They were already in here. The reporters were in here before.
Must have unlocked it like right after. So I just locked it. And I was like, I never should have. Like, I'm just gonna go back.
There we go again. This thing is really slow today.
What's up, Jess? Hey, can you try to find me a live stream of this? Nothing's popping up. This trial starts today, and they're supposed to be doing jury selection. It was supposed to start at 8:30, but there is not a single live stream anywhere. And to my understanding, they were live streaming this entire thing. I can't find anything on Court TV. I can't find it on Law and Crime. I can't find it on any of the local networks. Every single local network is in this courthouse right now.
I got some ear things for you
So
to try and help with that.
if you guys are just tuning in, we're trying to actually find a live stream. This is a pre-trial hearing that we're playing right now that happened a few weeks ago. So I'm just playing this for now until we can find something. But we cannot find a single stream that's up right now. Yeah, Kayla can't find anything.
I believe so.
All right, let's go on the record.
There's nothing.
Mark Jensen,
I understood that, you know,
2002
even the jury
CF
selection was going to
314.
be
Let's have the appearances, please.
The state appears by Carly McNeil from the Kenosha
was
DA's
going to be live
office
streamed.
and Robert Jamboy.
I tried even texting some of my like mainstream
Attorneys
media
Bridget Krause,
friends.
Jeremy Perry, and Mackenzie Renner appear on behalf of.
So I don't
Mr.
know,
Mark
maybe
Jensen.
court is
Mr.
starting
Jensen
late.
appears in person in custody. Good morning, Judge.
But you would think, like from previous trials, right? Like
Good morning.
even the networks
We
would
have
be
victim
showing a
notification from
clock.
the state.
We are in compliance.
All right, we are here for
Yeah, why would they not
motions, and
show that though?
It's my understanding the defense has 17 motions. Am I right on the number? Or is it 16?
What do you want? Want a job that I don't hate.
Sorry, we're dealing with ads because it's an old.
Judge, I don't have that many on my sheet. I know that there is a motion in limine that has multiple ones.
So we're trying to find something, guys. Just bear with us. Right now we're playing a pre-trial hearing that happened a few weeks ago. So this is kind of the last hearing.
All right, go ahead.
The state did count 17 defense motions, and those are numbered in the state's consolidated
Yeah,
reply.
They wouldn't do that though.
27th of 2022. So if it's not 17, then we're not sure what the number is.
All right. Well, I'm going to knock some of them off right away.
I mean, they don't. I'm going to turn the
Since
volume down a little
the
bit.
defense filed the motions, they should keep track of my rulings, and we're going to need some kind of order to be filed.
I mean, there's
so
plenty of
it's on
anonymity
file.
for the jury anyway, right? They don't show them. They don't say their
Evidence of
names and
rulings that are
stuff.
not being abided
Kenosha's
by.
not done that
So the
before in
first one
trials.
is the request not to use the word victim. I'm going to start out by saying that Wisconsin's always been giving victims rights. In 1993, we had a constitutional amendment, and it mentioned.
Yeah, it's supposed to be. The whole trial's supposed to be aired.
And now, as the attorneys.
And this is a big trial for not, Kenosha, but
The law of the state of
Wisconsin, but definitely
It
for
hasn't been
Kenosha.
overturned.
This is a major thing out here for
I
us.
believe when it was on the ballot, it was passed by 75% of the voters in Wisconsin.
And all these other hearings have been aired.
Marcy's law talks about, I think, at least 16 rights that victims.
Autocorrect slave my
And it
word.
mentions victims constantly. And
So we're trying, guys, just bear with us. I'm trying to find an answer. I'm trying to figure it out.
enforceable rights
Let
through
me,
the criminal justice process, just like the accused person has. And one of the interesting aspects of Marcy's law is if the judge doesn't follow Marcy's law, he can have consequences. Not the attorneys, but the judge. So that's how strong victims' rights are in Wisconsin. And it talks about.
Yeah,
and
bear
I
with
think
me.
the
I'm trying
exact
to.
wording in
I'm going to
one
call
of
the courthouse now.
Sections
Try to
talks
figure out
about
what's going on.
crimes committed by a defendant against a victim. It doesn't say convicted, it says committed. So I'm going to allow the use of victim. It's very, has a strong history in the state of Wisconsin, but we're not going to have a trial where we say victim 2,000 times. I think the state, they've have experience in numerous trials and they understand what I'm saying. But it's going to be allowed. This is a homicide case. There's the burden of proof beyond a reasonable doubt. I think the jury will understand what their role is, that they have to look at the evidence and base their decision on the instructions I give as to jury instructions, as to what the burden of proof here and all the other instructions, and make their decision as
God.
to that.
No, Wisconsin has horrible,
The word victim's going to
horrible
be
judges.
allowed. The other motion that I'm going to decide, I think it's the only state's motion. You can correct me if I'm wrong, but you want the jury to be able to ask questions during the trial, correct?
So that was a response to a defense motion.
So who asked for that?
The defense referenced that in one of their motions in limine, and the state's response was, let's just follow the jury instruction on that.
All right. If you're going to talk for the defense, you got to, I would say, which attorney's talking for the reporter, or the record's not going to be clear. So who wants to respond to whether I should allow the jury to ask questions?
Oh, you like Judge Schrader? No way.
I'm asking the court not to allow the jury
He's
to
the
ask
worst.
questions in this
That's my ruling. I think it's, I don't want to say a disaster, but it creates a lot of issues. If they ask a question
Right.
that's
So far, nobody has any
not
answers.
allowable under the rules of evidence, not relevant, it's difficult for them to understand. They want to ask their question and then they don't realize why they can't. And then, to be quite frank, sometimes it really
All right.
destroys
That didn't get us anywhere.
the party's prosecution. And they've worked so hard in their trial preparation, and suddenly this juror asks a question and they go, wait a minute, we don't want you to go there. And the other thing is, I think the original Jensen trial, and Mr. Jambo, you can correct me if I'm wrong, was the longest jury criminal trial in the state of Wisconsin.
I don't know who else to.
I don't know about that. It was the longest.
But that's
one
what I
I've
heard.
And it may well have been. It was,
Oh, the Halderson trial. Now, all right. So that judge
125.
was great.
Am I right
That
on that?
DA's office was great.
This case is gonna take long
That was by far the best trial that I've ever seen.
jurors to sit for 4,
That was a
5,
really good
6
trial,
weeks.
for
I don't
sure.
know how long.
That
That's
DA,
what the witnesses that we have,
they
just with the
really
questions the attorneys
like
are
went through everything step by step.
Generated
So yeah, that
fraud.
was a good.
allowing the jury to ask questions.
that
That's
was a
just
good
gonna
one.
Make the trial longer.
I'll agree with that for sure.
And I don't
That was a
think
really
it's
messed
gonna
up
get to the
case.
ultimate question, because I think The attorneys representing the state,
Um,
the attorneys representing the defendant.
I mean, the Brooks trial was good
Know what
too. You know,
questions they
Judge
ask,
Doro was
and
fine in
they
that
know
trial. It's
what their
unfortunate
defense is gonna
the
be
stuff
or
that
what
we
the
found
burden
out
of
about
proof
her
is,
afterwards.
and it'll come in. So we're not
That's
going to have
that's unfortunate, but
jury questions.
It's your home, and there's no
but yeah,
place like
quite a
right
few of
here to
these
make the morning
Kenosha
chaos
judges are
organized chaos.
actually kind of shitty. Milwaukee judges suck.
Discovery issues. I'm shocked that we have a discovery motion.
All right, so if you guys are just tuning in, we're watching a pretrial hearing that happened a few weeks ago because we are trying to find a live stream. There is nothing up.
Long time ago.
This trial definitely starts today, and
it's one of the best
jury selection is supposed to start. It was supposed to start at 8:30. We're trying to figure out why this is not being live streamed.
This case is in front of a judge for the
Because
third
our
time.
understanding is that this entire trial is being live streamed. It would be weird that
I don't want just we don't know.
the jury selection would not be,
Just to be clear, just
considering
last week,
every other
we
hearing for this has been
an investigator report from
live streamed.
2017. This is
All right.
the first time we've received it, so I appreciate that.
So just bear with us, guys. We're not like fucking around over here. We're really trying. Fish tank cleaner said, what do we find out about her? So here's an article that we released. I'll post it in the comment section. This will be on YouTube for those that are watching on Facebook. So you guys can check that out while we're waiting, I guess. But in short, basically, obviously we know Judge Doro is a Republican, you know, fine, nothing wrong with that, whatever. But her campaign manager is a far-right extremist. Judge Doro holds those viewpoints as well. So a lot of contradictions compared to what she said in her interviews. So we kind of wrote an article about some stuff we found out about the campaign manager and some stuff Doro said many years ago. So kind of unfortunate.
And then there's a letter from the special prosecutor to the
So a lot of viewpoints that really are, you know, a bit more right, you know,
So you want me to
radical.
trial date?
And you know, Doro's belief system kind of aligns with that, so it's kind of unfortunate.
You want to tell me what page that response to page?
Yes. So
Very misleading to
'Cause I know it's
what she
87
says or
pages.
vaguely says in her interviews. We found some contradictions to some lies that she's told.
this would be relating to defense motion number 12.
So yeah, bear with us, guys. We're trying to figure this out.
Page 21 of the state's response.
I'm gonna mute the mic. I'm gonna call the courthouse again and see what's going on. If you guys find anything, you know, obviously let us know. But right now, you know, we're just gonna watch this pretrial thing until we can figure this out. For whatever reason, I guess if it's not, the jury part is not going to be live streamed. You know, we'll figure this part out. But you know, we'll play this, I guess, in the meantime. This trial is pretty important, or this hearing is pretty important anyway, leading up to this trial. So some of you may have missed this, but bear with us.
All right, who wants to respond from the defense side?
So Judge, we do have the letter, it looks like, from 2016 on Aaron Dillard.
66.
I don't see anything on Bernard Bush.
Did you hear the statement as to Bernard Bush?
I did. And so if the defense can just specifically describe what they're looking for, then I can try to reply to that.
All right, why don't you do that for Ms. McNeil?
I'm looking for any promises that were given to Bernard Bush as
At
a
a
result of his
sentencing?
testimony.
Did you hear the response?
I did.
Okay.
So I believe that the letter in the state's consolidated response answered that question, but I can follow up on that. And
Why don't you follow up on it? So there's the only issue left is Bernard Bush. And we can revisit it if it has not been accomplished.
And Judge, another thing that we're working on is the updated criminal convictions for all our witnesses. And so we'll certainly provide those to the defense. We plan to do that before our judicial pretrial date in December.
I mean, I've had trials where we would wait to see if the person's going to testify. And then before they get on the stand, we figure out how many prior convictions are. And then we, obviously the witnesses talked too and told them the number. So I mean, I don't think that's a big issue.
Agreed.
Okay. I don't know how to bring up this other motion, but is the defense still wanting is it Mr. Thompson to testify that he sold cocaine to Bob Jamboys in 2006 or 7 or whatever that year was during the trial?
Judge, this is Jeremy Perry for the defense. We don't believe that what Mr. Thompson is saying is true. Okay, we think that this is a lie of Mr. Thompson's. We do think that his lie about this and his claim to say, or his willingness to say whatever. He wants to say to try to get him out of whatever situation he's in whatever moment he's in. We think that his lie is relevant in terms of being cross-examining him on that. And this is the state's witness. So he's
I don't care whose witness it is.
Well, it's the state's witness, and this is what the state's witness has told us has happened. And so
Give me a date that he told you this. Exact date.
It's June of 2017. That's June of 2017.
All right, so nobody in the courthouse is answering anything. I'm like leaving voicemails. One of my mainstream media buddies, so he's saying that it is supposed to be live streamed. So just like all the other cases,
That's when he told
you know, and like we saw with the Darrell Brooks trial, right? So Court TV. So for you guys that don't know, right, Court TV basically has the account to go into these courthouses and live stream the trials that you all watch, right? So they go down inside of a media room, and all of the local media goes down there. They plug in their little computers to Court TV's live stream, and then that's how, right, all the other big networks and everybody else ends up having the same feed. It's also why Court TV's feed usually lags
And where did he sell his
because they're
cocaine to?
providing the feed to everybody else. So
On a roadway in Salem.
same thing with this trial, with the Jensen trial. So Court TV is the one that's supposed to be providing the feed to all of local media.
I think I could take judicial notice that Mr. Jamboy was not the district attorney that year. And my understanding, he was working for the state of Wisconsin in Madison.
That is correct, Your Honor.
The governor had
From October, I started that job October 1st of 2005. And to Madison with my family.
so you're not in Salem?
So, bear with us. But, if you guys want to keep trying to let me know if you guys find something.
credibility
We're
of
still looking,
witnesses is
obviously.
always
We're
an
trying to
issue.
get some answers here.
We
Bear with
impeach
us.
them
This
based
is
on
supposed
prior
to
statements.
be live streamed.
We asked them about prior convictions, and if they give us the right number, we
this is
don't
really
get into
pissing
the
me off.
conviction. There's also other issues. Somebody's been convicted of some crimes that deal with truth, fraud. We bring that in.
Did they have issues? No, the weather's, it's cold, but it's bright and sunny out.
I'm shocked that the defense would ask for this.
And Judge, just to be clear.
Can I finish?
But the jury selection is always live streamed. Every court case.
I think it's Bush League. I think it's unprofessional. I think it's outrageous.
That's a matter.
I've been an attorney since
The jury
1983.
The
I've
jury
been a
selection
defense
is a matter
attorney,
of
an
public
assistant
record.
corporation
So
counsel, a municipal judge, a court commissioner, a guardian ad litem. I've never seen this. It's garbage.
I'll pause this
I'm
real
not going
quick.
to hold this ruling against Mr.
I'm going to pause this real quick. So for those of you that don't know, Judge Milisauskas, he's known for being a very, kind of brash judge, and kind of snapping on attorneys. So that's one element of this trial that's going to be absolutely interesting. Usually jury selection isn't televised. No, that's not unusual. Not in today's society.
Mr. Jensen. The record should be clear.
Especially out here
But I
in
think
Wisconsin.
On a professional standpoint, it's uncalled for. And to say that it's a lie, what power do you have to tell me somebody?
All right, so it looks like. So my buddy's saying that they're not doing the feed until tomorrow at the earliest. So they may not actually do the actual live stream feed until the case actually starts. That's fucking bullshit.
Somebody's lying now.
All right, so we'll watch this, I guess. I don't know.
Do you have some magical power?
That's irritating.
That somebody said something in 2016 about a drug deal in 2006 when Mr. Jamboy doesn't even live in that county? Well, one, maybe he's mistaken.
Here's what $5 a month with lemonade covers.
That's really irritating. And we'll get rid of this. All right, so we were obviously talking while some of this was going on. So basically what you're hearing is that there's an allegation that the original state's attorney, who is now back on this case, set up a drug deal between basically a jailhouse snitch. And this alleged drug deal was basically like a bribe to get this person to snitch on Jensen for something he said in jail. So that's what they're talking about. And it's kind of the way everything sounded. It sounds like it was kind of proven, but nobody's kind of taking this seriously. So kind of an interesting detail to this case. And then this state's attorney is back on the case, is kind of like a special prosecutor helping Kenosha retry this. So that's why Milisauskas is losing his shit right now about this.
And what is the jury going to think?
So I'll just rewind this a little bit so you guys can.
I've been an attorney.
About 2 hours from where I live.
So you guys can hear this because I was talking,
And
obviously.
where did he sell this cocaine?
16.
That's
All right, so it sounds like jury selection is probably not going to be aired in this particular trial, and Court TV is not going to start putting a feed out to networks until potentially day one of the actual trial, which is probably either Wednesday or Thursday, depending on how fast voir dire goes. But we're still trying to figure it out, so we might be wrong. We'll see.
11/2/2016.
when?
November 2nd, 2016.
That's when he told the investigator about this. And when supposedly did he sell the cocaine to Mr. What year?
Between 2006 and January of 07.
And where did he sell this cocaine to him?
On a roadway in Salem in Kenosha County at nighttime.
I think I could take judicial notice that Mr. Jamboy was not the district attorney that year. And my understanding, he was working for the state of Wisconsin in Madison.
That is correct, Your Honor.
The governor had
From October, I started that job October 1st of 2005.
Right.
And moved to Madison with my family.
So you're not in Salem?
No. About 2 hours from where I live.
Credibility of witnesses is always an issue. We impeach them based on prior statements. We ask them about prior convictions, and if they give us the right number, we don't get into the conviction. There's also other issues. Somebody's been convicted of some crimes that deal with truth, fraud. We bring that in. But I'm shocked that the defense would ask for this.
And Judge, just to be clear.
Can I finish?
Oh, sorry, Judge.
I think it's Bush League. I think it's unprofessional. I think it's outrageous. I've been an attorney since 1983. I've been a defense attorney, an assistant corporation counsel, a municipal judge, a court commissioner, a guardian ad litem. I've never seen this. It's garbage. I'm not going to hold this ruling against Mr. Jensen. The record should be clear. But I think on a professional standpoint, it's uncalled for. And to say that it's a lie, what power do you have to tell me somebody's lying now? Do you have some magical power? That somebody said something in 2016 about a drug deal in 2006 when Mr. Jamboy doesn't even live in that county? Well, one, maybe he's mistaken. And what is the jury going to think? What does this have to do with the guilt or innocence of the defendant? You're going to impeach Mr. Thompson. I think this is if I'm correct, because I did try to read everything, is the gentleman that was charged with 2 robberies in Illinois. Am I right?
Bank robberies, yes, Your Honor.
Bank robberies. So, I mean, how much? There's your impeachment. And Mr. Jambois did write a letter to I think it was the federal judge.
I wrote a letter to some judge.
Yeah. Well, whatever. But so we know that he got consideration for 2 bank robberies. I mean,
So for those of you that are asking what's going on during this pretrial hearing, so this witness that they're talking about with the impeachment of testimony, whatever, this is somebody that testified in the original trial, and they're accusing the former state's attorney, who is now back on this case, helping Kenosha retry this case. They're accusing that state's attorney of selling drugs to this witness, basically to get him to false testify against Mark Jensen. So this is something that happened in like 2016. And this is what Milisauskas is losing his shit about. For those of you that are just coming in, apparently jury selection is not going to be live streamed. So it's probably going to be another day, maybe 2 days before the actual trial starts, which it sucks. That's unfortunate. We didn't know that. So we're watching a pre-trial hearing. It's one of the last hearings that happened before this trial starts.
that's pretty good impeachment. And then the prosecution fulfills their obligations. So now the defense wants me to allow this defendant to say, yeah, I sold cocaine to the prosecutor who was trying this case.
Well, that's what it was.
I mean, if
reversed.
it was on the other foot and the prosecution wanted me to say, hey, one of the defense attorneys bought drugs from one of the witnesses, the defendant would be screaming. And if I allowed that in, I'm sure the Court of Appeals and the Supreme Court would say, what did you do, Judge? That is so damaging.
That's what it was. So the jail guy sold drugs to the state's attorney.
No way. It's reckless. It's just not professional. It has nothing to do with this witness. It is so outlandish that it would just confuse the jury. It's not the way to defend the case. But again, the record should be clear. I'm just making a ruling on this motion. The other portion was, I did read that Mr. Thompson said that.
How's the image quality on
Mr. Brantley,
YouTube?
Mr. Brantley couldn't do it, or was in Chicago or whatever.
It looks good on Facebook, but
it was in custody.
I guess I'm concerned about how it looks on YouTube.
It's not coming in, and I'm not going to hold it against Mr. Jensen. He has an absolute right to a defense. His public defenders can defend him.
Life with kids can be messy. Once Upon a Farm keeps
Sorry,
it
this is
clean
an
where
old
it matters
old
most.
video, so
We're
we're gonna have to deal with
All
commercials.
sorts of other evidence and witnesses, but this is not coming.
Good image on YouTube. Okay,
There's no probative value.
it's weird on my computer.
Confuse the jury to utmost.
So yeah, once again, sorry guys, we didn't realize that jury selection was not going to be aired. We assumed it would be, just like all the other trials out here. Guys, we didn't realize that jury selection was not. Sorry, testing out the quality here.
My understanding is that was filed by Attorney Vishny. because she
So
was-
we'll probably have to wait another day. So today's the first day of jury selection. It's probably going to take a couple of days.
I think she then filed
Yeah, the picture looks fine on my phone. It's just weird on the computer.
What's the motion regarding?
Motion limiting miscellaneous. It has a bunch of random things that were decided back in 2000.
I'll make a random ruling that we're not going to decide.
We would just withdraw it, Judge. I think that additional motions were filed in lieu of it.
The issue of hypothetical questions, is the defense still asking me to limit hypothetical questions?
Your Honor, this is Attorney Renner. Your Honor, we just want to make sure that hypothetical questions are limited in such a way that they can be understood by the jury. When we get into
It kind of sucks. We've tried to live stream court stuff before, but we were using a very old computer. It didn't work properly. So we've kind of upgraded. So this will technically be our first trial that we've actually live streamed properly. So we're gonna have a little bit of growing pains here.
I think, again, Mr. Jambo, as you can correct me.
Our other computer was never able to handle the streaming software and doing all this stuff. So,
two hypothetical questions. That's how much I read the transcript.
So we're kind of doing a test run with this trial.
2 times.
But yeah, so if you guys are just tuning in, jury selection started today. Apparently, that is not going to be live streamed. And Court TV is not going to start airing stuff until day 1 of the trial.
You want a fair trial?
Possibly tomorrow at the earliest. So we'll try this again.
Hypothetical questions are allowed.
But today we're gonna, we'll play this. Maybe we'll play a couple of old trial clips, kind of get you guys acclimated to what this trial is all about.
As to an expert, and I've read it so many times.
This is a big trial for us out here in Wisconsin. It's a big deal.
The judge says to the jury, "You are not bound."
Thank you for the follow, Rachel. Appreciate it.
You don't have to listen to any expert. I mean, the only civil case where you need an expert is a medical malpractice case. That's the only one. All the other civil cases, you don't need experts, and the jury doesn't have to listen to them.
Yeah, I agree, Nance. That's why I am really surprised that jury selection is not being live streamed.
And again, even some of the facts,
especially with as important as this case is,
experts don't have to be in evidence. They can be facts that they considered. So I understand what the defense is saying, and we don't want a hypothetical question.
I mean, for the Rittenhouse trial out here, they did the jury selection. They named all the witnesses, right? You guys remember they said my name out loud as a potential witness because I was out there.
Just go by the rules of evidence. It's kind of like a boilerplate motion in limiting that attorneys file.
Milwaukee does it.
Most of the boilerplate requests are rules of evidence that we all follow.
Yeah, he's been in jail the entire time.
Here this morning, the attorneys are
so here, let me pause this. I'll kind of tell you guys. We'll give you guys a little background. Some of you might be new to this case. So here's kind of the short rundown of the Jensen thing. So the original attorney that represented Mark Jensen was Deja Vishny. Some of you might remember that name from during the Kenosha unrest. So Deja handled a lot of the civil rights cases pertaining to Kenosha. She handled my unlawful arrest being a journalist in Kenosha. Deja is, she's an attorney that handles very high profile cases. She's kind of retired at this point, but she comes back for like some very high profile things. So basically with this Mark Jensen thing, so he was convicted. So this case goes back to 1998. Okay. And that's when the wife died. It took a long time for this case to actually come into the courts. But he was convicted originally in February 2008 of murder of his wife at their Pleasant Prairie home, which is another city that like borders Kenosha. So it will have been 14 years, 10 months, 20 days since he was convicted of killing his wife, Julie Jensen, almost a decade earlier in 1998. The case has been in and out of multiple courts for decades now. So Jensen and his attorneys, obviously today, are appearing in front of this particular judge, Anthony Milisauskas. This judge is very crass. He's kind of rude. Obviously, you hear his tone. I've been in front of him for my divorce. The guy's a fucking asshole. He's known for snapping on attorneys, like you kind of heard, him snapping on the defense there about this whole cocaine thing. So this trial is expected to last 5 to 6 weeks. Opening statements are expected to start on Wednesday, so we can assume that that's when the first airing. So jury selection Monday, Tuesday, and then opening statements Wednesday. So last year, Milisauskas ruled that a key piece of evidence, the so-called letter from the grave, used to help convict Jensen of killing his wife, will not be allowed into evidence during this retrial. Jensen was convicted originally on evidence that included the letter that his wife wrote before her death and gave to a neighbor. In that letter, she wrote, "If anything happens to me," that her husband would be the first suspect. So that was a big thing that was used to convict him. And that letter was revealed after her death. In early 2022, a U.S. Supreme Court rejection helped pave the way for the new trial. The nation's highest court declined to hear the case after an appeal of the Wisconsin State Supreme Court ruling that Jensen should receive a new trial without the letter used as evidence. So, this has been back and forth with the higher courts and everything. The Wisconsin State Supreme Court said that he should have a new trial. The state tried to take it to the U.S. Supreme Court, and they refused to hear it, which is what is bringing this to trial now. Jensen has maintained his innocence now for decades. His attorneys have argued Julie Jensen was depressed and we gotta say certain verbiage here, but unalived herself after framing her husband for her death. Prosecutors argued that Mark Jensen killed his wife with antifreeze in order to be with his mistress, and that he searched the internet for ways to make her death look like unaliving. He later married the mistress, right? Jensen has, so to answer your question, Jensen has been in custody in the Kenosha County Jail on a $1.2 million bond. Was previously sentenced to life in prison with no chance for parole by Judge Bruce Schrader. That's the Kyle Rittenhouse judge. Schrader presided over the original trial that was moved to Walworth County in part because of the pretrial public interest. The original prosecutor, Robert Jamboy, a former Kenosha County District Attorney, will also return to prosecute the case before Milisauskas, now the third circuit court judge to preside over the case. Jensen was sentenced in 2008 after a jury convicted him. A series of appeals followed, and in 2013, federal court overturned his conviction and ordered that he be retried or released from prison. Federal judge ruled Julie Jensen's letter was harmful to Mark Jensen's defense. When a second prosecution began in 2017, Kenosha County Circuit Judge Chad Kirkman ruled the letter should be admitted, and Kirkman reinstated Jensen's conviction without a second trial. Wisconsin Supreme Court ruled in March 2021 that Jensen must receive a new trial and that the letter and incriminating statements his wife made cannot be used by prosecutors, which ended up, all these different appeals and all of this. So, but basically the ruling is that the letter violated Mark Jensen's Sixth Amendment right to confront witnesses against him. So that's a little background for you guys. The short of it, anyway. So we'll watch this. We'll probably play a couple of clips from some of the previous trials, sentencing, all that. We'll play a little bit of that, and then I guess we'll try this again tomorrow and see if maybe they go live tomorrow. If not, then it sounds like Wednesday will be day one of the trial. But, stick around for this. This is obviously very important information. This will kind of get you guys caught up on some pretrial rulings, give you guys a little insight to how this case is going to be ran by this particular judge. And feel free to ask questions about whatever, not only this, but, whatever else.
Aware of the rules of evidence and have previous trials. So we'll just leave it to what the jury instruction says.
Rachel says, how do you feel the note being left out will affect the outcome?
Sequestration.
I don't know. This is a hard one. I mean, I think they're definitely going to use the computer again, right? Because there's apparently searches on the computer for poison and unaliving somebody. So I'm sure that'll come in again.
Maybe I should say something different.
I think the notoriety of the case, I think he's going to get convicted again, but, we'll see.
Different position is when the state comes in with their...
There's nobody that doesn't know about this case, at least here in Wisconsin.
Investigation, and we allow that, and sometimes the defense has an investigator. We allow that. Is the state asking to have any exceptions?
Yeah, for sure, Glenda. Comments, where you guys are tuning in from.
Who's that?
So right now we are
If you're watching on our Facebook page, make sure you guys like and follow the Facebook page. Watching on YouTube, make sure you guys subscribe to the channel.
Certainly, there's a lot of witnesses in this case, so we're going to have to, when they're waiting to testify, we're going to have to have them, right, just in one room, though. Would that be okay?
As long as you tell them, and I tell this is the attorney.
So if you guys are new to us, I'm an independent investigative journalist. We cover a lot of stuff in Southeast Wisconsin, more investigative style journalism. We kind of focus on some civil rights issues, corruption within systems, things like that.
There's so many witnesses that really they could be all over the place if they had to be in separate rooms. Some of the witnesses are married to each other, so certainly they're going to be coming to.
And it's the same thing for the defense. You tell your witnesses can't talk about.
I don't know if he's a former Brooks attorney or not.
Say whatever you want, and it's your obligation to control your witnesses. And if I find something that's happening,
How does he afford that? I don't know.
I can't. This is such a small courtroom. We have so many witnesses. I think it would be very hard to police what's happening with the witnesses, except for the parties. And we will give them that responsibility. So.
I got the impression because, again, his former attorney, Deja Vishny, was my attorney for the unlawful Kenosha arrest when we were out there filming the riots and stuff. And, she obviously didn't give me details of the case because she can't, but kind of talking to her about this, she was pretty excited that this had gotten kicked back for a second trial. I kind of sensed from her demeanor and kind of tone that she felt pretty strongly about his innocence. So I thought that was kind of interesting.
What offer of proof can the state give me that how you're going to?
On most vacations,
I mean, we'll
you
see
take a
how
trip.
But this
in
plays
Israel,
out. But
you'll take a journey you'll never forget.
Sorry, we're going to deal with some ads here.
We know the computer's in the home.
Correct.
So what offer of proof are you going to?
So we're going to spend an extensive amount of time, as was done in the first trial, demonstrating when the computer was used, like time of day and dates that it was used, and the certain topics that were accessed on the computer. So of course the state's overall argument is going to be that this use regarding poisons and things of that nature was done by Mr. Jensen. So really this appears to be more an argument over terminology But the state intends to prove, based on the totality of the computer evidence, that the person making the searches for things that would be evidence of guilt was the defendant.
I think that's appropriate. And you could argue in your closing or wherever.
Yeah, you might be right there, Glenda, about that.
Computer in the family home, and obviously the state's going to argue that it's Mr. Jensen that used it. But that's a fact issue, and that's for the jury. I'm not going to make a ruling that they can't say that eventually. That's a jury question. They don't believe the fact, they don't consider it. I'm not going to make a ruling on evidence today whose computer it is, because that's an issue again for the jury. Okay, let's go to something else now.
The second part of it, I'm sorry, was the defense requested in order that no witness be asked about the intent of a person who deleted history, files, or specific phrases that would be speculative.
Is that including experts?
I think it was including experts.
I think experts can get into that. That's why they're going to be here. They're going to say this is what happened. I mean, people are shocked when they delete something. I'm not a computer genius, but I know one thing. They can find anything once it's in a computer on your phone. Everybody always thinks, it's deleted, or I've only sent it to this site, they'll never find it. These people, experts in the computer field, are well paid. They can find anything. And if it gets into his opinion, he can give his opinion what happened. Again,
I got a bird outside my.
I said,
hang on, let me pause this. So I have a window unit air conditioner just to my left, and I got a bird that a mama bird who has built a little home in between like my window unit and the windowsill, and she's got her little babies out there. So yeah, you're not going crazy. There's birds.
We're not going to have a lay witness make that opinion. It's going to be an expert. So they want to get in that area, and you could cross, the old idea of cross-examination. Ask the question: how can you come up with that opinion? What facts did you use? What did you do? And that's how you cross experts. You have that opportunity. I'm not going to limit the expert as to his statement and his expertise here today. So if he wants to make that opinion, and then you cross him and destroy his opinion, well, then the jury decides what facts are relevant as to what was deleted from the computer. Okay, what's next from the defense?
There are a couple of motions, I think, that are really along the same line. One is one filed on November 29th, 2016, amended motion and memorandum of law in support of motion to exclude improper opinion testimony, and this has to do specifically with Dr. Long.
Yeah, but I think one of your experts used evidence that's not even allowed in, and was using it in their report. So I think Ms. McNeil, she used a very good legal terminology. Can you repeat that for me? I don't want to get it wrong. What's good? What's good for the goose is good for the gander. I don't know what case that comes from or what statute it's from, but that's what I'm going to rule. Experts, I've had so many experts.
So obviously when the actual trial starts, like I'm not going to talk over this stuff. We'll talk during breaks and things like that. We'll have the mic muted so you can't hear the little birds outside my window.
Tell the attorney, I can't try the whole case. They wanted me to try everything, every little issue. I said, what do we need the jury for? We're going to try the case. It's not a court trial. So if you have an issue with an expert, with their report,
but yeah, if you guys are watching on Facebook, or YouTube, if you're new to Never Stop Media, we have a YouTube channel. It's called Never.Stop.Voices. There's a lot of focus on what was happening in Kenosha. Hundreds of exclusive videos on there on our page that people have never seen. We do have a website, Never.Stop.Voices.com, where we write articles. We focus more on investigative style journalism, so we kind of pick and choose certain topics that we're investigating. Our investigations take months.
And back to the Wisconsin Supreme Court. In fact, it was a unanimous decision by the Wisconsin Supreme Court that this letter was not.
So on YouTube, there's tons of different links that are popping up. Facebook, there's not going to be. We do have the chat parameters set pretty high on both Facebook and YouTube. So try not to type in caps. Try not to like spam with emojis because our night bot on YouTube has an attitude problem.
Not the contents. Experts can
And it likes to time people out.
inadmissible evidence, but it's whether they can testify about the specifics of that inadmissible evidence.
Is your expert going to be able to answer the contents?
And I'll be responding to this. Go ahead.
So if you get timed out on YouTube because you put some emojis or something, that's not us doing that. That's
the state intends to ask Dr. Long
our little night bot.
about the amount of ethylene glycol in Julie Jensen's body. We were not going to be asking Dr. Long about the manner of death in this case. We're simply going to ask him about the level of ethylene glycol in the body.
So why can't they ask him that question?
They can, as long as he doesn't say that his opinion is based upon the letter that Julie Jensen wrote that her husband, about her husband, her thoughts of her husband going to kill her. That's my concern, Judge. I have no concern about them asking Dr. Long about the level of ethylene glycol. That's not what's in the motion. The motion is very specific as it relates to the letter that has been excluded by all courts, except for the circuit.
Well, Your Honor, if I may respond. The state is not intending to introduce the letter at any point in this case in chief. However, it's not true that any reference to the letter is inadmissible.
I know it, because there's non-testimonial evidence by other witnesses that the letter can come in.
No, the non-testimonial evidence from other witnesses is that there was an existence of a letter, not the contents of the letter. I mean, there's a big difference there, Judge. The calls versus the contents of the calls.
All right, we'll stop it right here. I don't think the state is telling me they're going to use the content of the letter, and it's not going to, the content of the letter is not going to come in.
Your Honor, I'll just say this. What the Wisconsin Court of Appeals said in Jensen 2 was that one of the reasons that they thought it was harmless error for the letter to be admitted is because everything that was set forth in the letter was attested to by other witnesses. And so that's the content of the letter. Most of the content of the letter was attested to by other witnesses in non-testimonial statements. So even if the letter hadn't come in, the jury would have heard, for example, about the Post-it note because Julie had testified about or had spoken about the Post-it note to other witnesses. And references to the letter are admissible. References to the content of the letter are admissible. It's the letter itself that is not coming in the state's case in chief. Now, when
I'm going to stop you here. We're not going to decide this issue today. If the defense wants to give me a written argument within 5 days, I'll consider it. And the state wants to respond in 5 days.
Are we talking very specifically about the contents
Just
of the letter?
that's all. No other issue. So I don't want to get my
Only, Judge, the only reason that I ask is because there is a difference, and I understand that Attorney Jamboy is talking about Jensen 2, which was overruled by both the District Court, the Seventh Circuit, and the Wisconsin Court of Appeals because they found it wasn't harmless error, and in fact, it wasn't duplicative because there is a defense to that. And
all right, you got till November 25th at 5 p.m. The state can respond by December 2nd, 5 p.m.
And Judge, I think that's going to be
very limited issue. I don't want nothing else briefed. I got too many briefs on this case.
Judge, I was just saying that there's a motion to exclude references to testimonial statements. I think that the court is going to hold off on ruling that motion then until this because they're the same thing. It's really about the contents of the letters being mentioned by citizen witnesses.
Why would I not allow non-testimonial statements?
I think the court would allow non-testimonial statements as long as there's a hearsay exception to those statements. That's not what I'm talking about. I'm talking about in reference to the contents of the letter.
All right, it's the same issue.
Yes. So I would
So,
ask
Your
the
Honor,
court to hold off on ruling there until we file this.
Well, Your Honor, I will say this. I think this issue has been sufficiently briefed, but if the court wants additional briefs, we're more than happy to provide them.
Do
I
me the
will-
favor, help me out.
Yes.
I'm a senior citizen now.
There's a lot here, Judge, so I understand.
Defense counsel just made reference, however, she said, well, we've got to satisfy some hearsay exception. And the answer is no, we don't. Because what the Court of Appeals in Jensen 2 said, and by the way, Jensen 2 was not overruled on all points. They were simply overruled on the point that it was a harmless error. That's the only part of Jensen 2 that was overruled by the federal district court. But what the Court of Appeals said in Jensen 2 is that the Wisconsin Supreme Court in Jensen 1 adopted a forfeiture by wrongdoing doctrine, a broad forfeiture by wrongdoing doctrine, which does not survive Giles, except with respect to non-testimonial statements. So with respect to non-testimonial statements, the forfeiture doctrine applies. And in this case, Judge Schrader, after a multi-day forfeiture hearing, determined that Mark Jensen was responsible, more than likely responsible for Julie's failure to appear or inability to appear. So therefore, the defense does not have a hearsay objection to any of the hearsay statements, that non-testimonial hearsay statements. That was the ruling in Jensen 2, and that is the law of the case here. And then this whole notion about references to the letter in non-testimonial statements, that's also the law of the case. And the law of the case is that the references to the letter in the non-testimonial statements are admissible. The Supreme Court said that in Jensen 1, the Court of Appeals said that in Jensen 2, and there's nothing in Jensen 3 or any federal court that changes that ruling. So the references to, in non-testimonial statements, the references to the letter and the descriptions of the letter are all admissible, and that's what the appellate courts have said.
I'll make that ruling when after I get that brief.
Thank you, Judge.
All right, what motion do we have next here?
I think there's a motion to reconsider the decision denying defendants' motions to suppress the book, as Attorney Jamboy calls it.
To reconsider what?
Judge Kirkman's decision to allow in the book that was recovered.
Do you have
from
any
Mark
new
Jensen.
evidence, anything new that he didn't consider?
This is Jeremy Perry. No, there's no new evidence. I think that
Your motion's denied. What's next?
There is a motion and numerous responses as it relates to specific instances of, I believe, untruthful conduct of Ed Klug.
That's
And I
the
think
other
Attorney-
X motion that you have on Mr. Klug?
I think Attorney Renner's going to talk about that, Judge.
What can, Ms. McKeel, can you tell me what page your response is on?
Yeah, so this will be in the 87-page response, and there's two different responses, so let me get those for the court.
Meanwhile, on Paramount Mountain.
All right, let's do this roll call. It's freezing up here. Where is Big Naughty? Is Big Naughty up in here?
It's Nate.
Say your name right.
Nate.
Naughty.
Nate.
Naughty.
Nate.
Say it right.
Nate.
Naughty.
Nate.
Naughty.
Nate.
Naughty.
Nate.
Naughty.
Nate.
Sorry about the ads, guys.
Santa Fe
Nothing I
versus
can do.
Honda Passport. Hyundai Santa Fe.
Try to skip them as fast as we can. So once again, if you guys are just tuning in, the jury selection is not going to be live streamed. So this trial probably won't start until Wednesday morning.
All right, thank you.
We're playing a pre-trial hearing. This is one of the last hearings. We'll play a couple of clips after. We'll play an interrogation video that that's out there. and we'll
far
play
as the state's argument that the
Judge
district
Schrader's
attorney,
sentencing
who
during the
ultimately
original
was
trial.
charging Mr. Klug at the time in regards to a statement that he had not hit a casino machine when the video showed that it had, according to the criminal complaint, I believe is inapropos, just because the state decided not to charge or determined that they could not meet the burden of beyond a reasonable doubt does not preclude other acts from coming in. As far as his financial dealings, I believe most of these would go to bias and need for money and ability to potentially collect on his notoriety that comes from this case. I think the question for the court is, under the rules of evidence, are these going to be considered specific acts of untruthful conduct wherein I have to accept the answer of the witness without being able to impeach using extrinsic evidence, or whether this is going to be allowed as other acts because there is such a pattern of untruthful conduct by Mr. Klug that at this point the pattern would allow us then to impeach by extrinsic evidence.
Well, as to the financial information, there was the correct terminology is FINRA. It's got to be some sort of.
It's like Oler for stockbrokers.
It's got to be some kind of board that if you do something wrong, they investigate you. They found that there was no issues as to what the complaint was about on all the complaints. There's no police reports. There's no complaints to the IRS. There's no complaints to the SEC. You still have to prove your other acts by the preponderance of the evidence, and a lot of the issues dealt with the divorce proceeding, the issues of the financial misconduct. There's no criminal charges. One of the complaints was filed by somebody who had a bias towards Mr. Klug. It was out of a divorce case. There's depositions talking about certain financial testimony, and I don't think that goes to any untruthful statements. And but I do have an issue with this criminal charge. I mean, the financial issues. There's a divorce. There was some complaints. There was no findings. There was nothing. But the criminal charge. What information does the state have as to exactly? I want something concrete, just not a statement. Why the state dismissed the charges?
So our belief that we put in our response is that the ADA concluded that the video did not show Mr.
Yeah, but do you
Klug.
have something in writing that's her statement, or is that just your belief?
So that's what I have right now. The defense did respond to the state's response and indicate that they were going to look into this issue further, but I have not heard anything else.
Has the defense looked into it further for why they dismissed it?
Your Honor, unfortunately, being a defense attorney, the DAs don't feel the need to tell us why cases are dismissed.
So, Judge, I can see if this ADA has any ability to look up her file and provide something. Maybe she can email or something like that. The other thing I would note about this criminal case is that it was alleged to have occurred in April of 2016. So at the time of trial, we're approaching almost 7 years later. So regardless, I would like the court to take into account the time that has passed.
I usually use 10 years. I've used that on all cases. So it's within 10.
And also to be clear, Judge, obviously this was a case that was dismissed. However, I can see if this ADA, if she's still an ADA, would be willing to respond to us and look at her file.
I'm going to allow it unless you give me something else from the DA as to her reason for dismissing it.
And Ms. McNeil, if you are able to reach out to the DA, we would appreciate the ability to see the video if it exists.
I will see what I can get from this ADA. Again, if she's still an ADA, I don't know her at all.
All right, what do we have next?
Judge, I think all that's left is standard motion and limines.
Which motion and limiting issues do we have?
Attorney Vishny, I think, filed one, and then I filed a subsequent one.
What's the issue in those motions?
And Attorney Vishny's filed August 14th of 2017. There's some information specifically.
What's up, JK? Sorry about the ads, guys.
Why are these so bad?
We'll try to
If
get
I
rid of
wouldn't use
these
kayak
as
to book our
fast
car, we
as
could
we
have saved
can
on
on
our
these
trip
things.
instead of during our trip.
So I will put up a. We have a copy of the letter.
One and done.
So we'll pop
New
that up
Year's
after this as
resolutions
well.
do not work for
So
everyone.
you guys can see
but
that.
here's the good news. There are a lot of
Laura Koster. We already took care of number
So
2.
once again, if you guys are just tuning in, we found out last minute that the jury selection will not be live streamed. The case is not expected to start until Wednesday morning
I would not argue.
with opening statements. So
Number 4, I believe Attorney
if
Jamboy
they go
agreed
live
that
tomorrow
they
morning,
talk
we'll
about
go
the fact
live.
that
If
he was
not,
convicted or
plan on
sentenced.
Wednesday morning. So right now we're just
So what
watching a
ruling do I
pretrial
have to make
hearing.
here?
This is one of the last hearings that happened.
I
We'll
think
play a
number
couple of
4,
clips after this
Attorney Jamboy
from the
agreed,
original
so
trial.
I guess the court could grant
We're
it.
gonna show you guys the letter
So just so
that
we're
will
all
not
looking
be
at the
used
same
in this
document,
trial.
This is from August 14th of 2017, and this is the one labeled motion in limine to preclude prejudicial evidence, admit evidence, and set forth procedural trial matters. Is that accurate?
That's the one I'm saying, yes.
Well, I still don't know what the issue is.
There are 9 motion in limines that Attorney Vishny filed, and then there are 6 procedural.
All right. And you talked about some that both sides have agreed to already, right?
Correct.
So tell me what's
Number 2, the court already ruled on as it relates to victim, so that has been settled.
okay.
Number 3, any evidence that Mark Jensen intended to publish or earn money from a document seized from his cell.
Has that been decided?
It has not.
Is the state going to bring in that? Obviously, the books issue's coming in, but are you going to bring in that he earned money off it or he wanted to earn money?
We were planning on making some reference to his motivation in writing the book. It was to tell his story, and he expected to make a lot of money off of it. And it's the defendant's own words that we're going to be using. It's,
What does that have to do with the guilt or innocence?
well, it's the motive for writing the book, and the whether and he's indicated it's his purpose to tell his story, and that he was going to make a lot of money off this book. And money was one of the reasons the defendant murdered his wife, so he wouldn't have to pay child support, so he wouldn't have to split up his assets with her. Money is a motivating factor for Mark Jensen throughout this case, and the state is allowed to present evidence concerning motive for the crime. That's one of the reasons that the state will be requesting certain portions that would be admitted into evidence, is because of.
Don't we tell the jury that we don't care about motive?
No, we don't tell the jury. We tell the jury that the state's not required to approve motive.
That's what you said it better than I said.
But nonetheless, motive is something that the state can prove. It can demonstrate.
I agree. They can bring it in. It goes to motive. Might not be true, but it goes to motive. So it's coming in.
Number 4, any evidence that Mr. Jensen was previously convicted and sentenced in this case. I believe Attorney Jamboy agreed.
We're not bringing that in.
The state does not plan to bring that in. I will say this, Your Honor. The defense did not file a motion for change of venue. And the odds of us picking a jury in Kenosha County that doesn't know that Mark Jensen was previously convicted of this crime, I just don't see how this could be possible.
Well, that's their decision.
We're just asking that they don't bring it in their case in chief.
It's not coming in.
Yeah, so we just said jury selection started today at 8:30 and expected to last today and tomorrow. It will not be live streamed. So we thought it was, and we found out that it is not. Opening statements are expected to start Wednesday morning.
And both parties, everyone is to avoid argument. So we agreed to abide by those rules of opening statements.
We don't give the juries an opportunity.
So for some
to take
reason,
notes during
jury
openings and
selection in this
closing,
case is
and
not
there's a
being
jury
publicly
instruction, and I
aired.
read that opening and closings are not factual statements. They're not to consider it. It's just an opening is the obligation of either side to show what they're going to prove or what they're going to do. And then when we do the closing.
So if you guys stick around, we're going to play some clips from the original trial. We're going to go through, we have a copy of the letter that Julie wrote. So we're going to pull that up for you guys.
We'll just abide by the rules of evidence.
We'll kind of give you a pretty detailed history on this case. We'll kind of go through that. Some issues surrounding the case, how the case was handled originally, some background on Julie, background on Mark. So we'll give you guys a whole history of this.
All right.
And
Preclude the prosecutor from
if they go
eliminating
live
evidence
tomorrow,
of conversations
great, we'll go live. If not, plan on Wednesday morning.
Well, what we responded to this.
We expected this to be live today and found out last minute it wasn't going to be. So
phone call, it's not just the voice of the person. So we certainly will be abiding by the authentication.
Again, it's the rules of evidence. However they bring it in, they bring it in.
Any evidence the defendant has committed other bad acts not previously litigated before the court.
Do you have another X motion on the defendant?
So what we had indicated, and I believe this is in our motions in limine, is that Judge Schrader had allowed at the prior trial other acts of the defendant, and that those are the only other acts we intend to present again based on the prior ruling of Judge Schrader in the case.
Was that issue appealed?
I don't believe so. If it's the panorama evidence, I think that's already been also Jensen 1. That's the rule. That's the law of the case. So
what other acts did the state bring in the original Jensen trial?
The other acts, Your Honor, from the last trial particularly pertain to the defendant leaving photographs around the house and claiming that photographs were left on the windshield of his car. These are photographs of a female head in close proximity to an erect male penis. And the state
can we do the letter soon? Are you guys getting impatient?
That she'd had in 1991.
Here, I'll text you, JK.
This evidence was deemed to be admissible by Judge Schrader because it was related. It demonstrated the defendant's hatred for his wife and his motive to kill her, and that's why it was admitted. And the state had a significant quantity of evidence supporting that, including testimony from the officers who investigated those instances, and also a private detective that Mark Jensen himself had hired, who also came to the conclusion. All the officers and the private detective advised Ms. Jensen that it was Mark Jensen that was doing this. And Mark Jensen, during the course of his interview with Detective Ratzberg, conceded that he had on occasion planted these photos around the house as a means by which to get back at his wife when they were having arguments. So that was the other evidence.
that's the law of the case. It's already been confirmed by the appellate court or by the Supreme Court in Jensen 1. So that's not what this motion is. It says not previously litigated before the court.
Yes, and the state does not intend to present additional other evidence beyond what's contained in the book. I mean, there are references to things he wrote in the book, but those are all statements by a party opponent. And the state is not contemplating any additional other evidence.
All right, then we got it.
I wanted a master's degree, but 2 years to get one? No thanks. Then I found WGU. On average, WGU grad students finish in 19 months. A university where I can get my master's faster? I choose
Sorry
WGU.
about the ads. Nothing we can do.
In agreement. Let's go on to the next question.
As to the stuff in the book, we haven't received notice specifically about what they're trying to put into evidence. So if it's an other act, we would need notice of that. The book was not litigated before Judge Schrader. Or
did I hear you, or did I not? You said you're not going to use other acts from the book?
No, what I said is that there are references in the book. There are things he wrote in the book that we will be using, and we have notified the court and council that the state would get that to the court and council sometime in advance of the final pretrial in December, which is scheduled for December 16th.
We'll wait for the final pretrial to see if it's given to the defense.
So we'll hold off on number 8.
And just remind me.
Okay. And then the last one the court already took care of as it related to discoverable material. I think we discussed that already.
All right.
The procedural things that Attorney Vishney, we already took care of number 1. We're not going to allow jurors to ask
So
questions.
yeah, make sure you guys stick around. We'll pull up a copy of the letter for you guys. We'll go through that. We'll play some clips from the original thing. We'll play a portion of the interrogation. And we'll kind of go through a pretty detailed history of kind of this whole thing. Give you guys a bunch of background so that when we get to
what I normally do
opening
is I
statements
ask
of
the
this
state
trial,
the
you guys
name of
are,
the witnesses,
pretty
and then I
fully
just say if there's any
acclimated to
additional
what the hell's
witnesses the
actually
state
going on.
wishes to name. I mean, the defense wishes to name.
Okay. That all proceedings be recorded, including sidebars, voir dire, opening, closings.
It's up to the attorney what they want to do with their sidebars. I have trials where the lawyers run up and do a sidebar, and then we take a break and they never put it on the record. That's not my responsibility. It's the lawyer's responsibility, how they want to handle it.
So just, I want to know how.
Wisconsin Supreme Court in Jensen 1.
If you had an objection and you come up and do a quick sidebar, tell me that when we go on a break, you want to put it on the record. I think that's the proper way of doing it. I don't like it when the jury has to keep going back in and out every 10 minutes. They get confused. They say, well, what are they talking about when we're not in here? So just say, I want a sidebar, come up here and tell me what you want, and then tell me I want to put it on the record when we're not having the jury.
Judge, as to objections, does the court just want like hearsay and then we do a sidebar, or do you want speaking objections? I would ask the court to limit speaking objections, obviously, for the reason that not some of that information should always be in front of the jury.
I think objections, you do have to give me a reason, but I don't want you to start arguing in front of the jury. Give me what evidence I should not allow, hearsay or confrontation,
Yeah, they're
whatever, but don't start arguing.
They lived in
because
PP.
That's not what the jury should hear.
I think number 5 the court probably does, which is prior to the opening statements of counsel, the jury be instructed by the court as to the elements of the offense charged.
I do instruction 50, and I think the state gives me the elements that I have to read as to the charge in that number 50.
Thank you. And number 6 is the jury be given written instructions for use during deliberations on the instructions that are within this document for the proof, presumption of innocence, elements of the offense, and any other instructions deemed by the defense after close of evidence to intervene to be issued. And I think we could probably do that during the jury conference.
We can do that during jury instructions.
I don't think my motion in limines that I filed are anything more or less than that, honestly. I filed mine because we had a deadline and I wanted to make sure it was filed, and honestly, I hadn't gotten through everything yet. So I think the court probably ruled on all of these. The only one we have to talk about, we already talked about the book. We talked about criminal convictions. The court's fine with doing that prior to the witness testifying.
Right.
We are going to talk about the letter. I think that's in my motion in limine in the voicemail, so I think that's the motion that the court asks us to file by Friday.
I will give you a ruling then when we come back at the pretrial on the 16th.
Okay. And then there's pretty just standard. I think Attorney Jamboy agreed. They're just standard instructions like state be precluded from introducing any evidence or medical records which haven't been provided. Oh, Judge, I'm sorry. As it's the one that Attorney Vishney filed, there is one specifically as it relates to Laura Koster. There's a number of different, there's A through F to exclude evidence as it relates to Laura Koster being a witness for the prosecution of her father from 1989. It has no probative value, and we're asking the court to exclude it. Judge Schroeder did not permit the state to cross on this issue.
You can't like the links.
Well,
Well, since Judge Schrader.
I don't know.
We're not challenging.
All right, we answered that question.
Thank you.
Yeah, that's weird.
So these all look like they were things that were not allowed.
We posted some links on Facebook.
Judge Schrader did not allow the
We got people watching on
prosecution,
YouTube and
questions of
Facebook.
forfeiture by wrongdoing. What does that mean?
On YouTube, all of our links are popping up automatically. On Facebook, I gotta post them manually.
Thank you.
It all started with that mix. Man, I was obsessed with it.
So are there any in A through F that the prosecution disagrees with?
Yes, so the next one is C.
So once again, we're watching a pretrial hearing that happened a few weeks back. After this, we're going to watch some other clips from the original trial. We're going to show you guys the letter, and we'll give you guys, some pretty detailed background on this case.
And then in their subsequent testimony, it appears that
Opening statements are expected for Wednesday morning.
that the state should be allowed to.
We thought jury selection was going to be live streamed. Apparently, it is not.
That's right, and apparently during the trial, there was the implication that she had withheld information. And so the state, I think this is kind of a general principle that if the state believes, based on a prior transcript, that someone has withheld information, that the state should be able to inquire into that.
I think it's an inconsistent statement, but if she wasn't asked, she couldn't have answered it. And I think there's a distinction there.
Sounds like a great cross-examination question.
I would just ask the court not to allow testimony that was
I'm not going to
asked.
try the whole case. It's not a court trial. You want to waive jury? Okay.
If you guys are watching on Facebook, make sure to like and follow the page. If you're watching on YouTube, make sure to subscribe. We are going to be live streaming this trial when it actually starts, and there's streams up.
Can I ask a hypothetical to a lay witness?
Yes, we believe that hypotheticals are allowed for lay witnesses, and we cited 907.01 for that.
What was the question? Do you remember what it was?
I think it was about
questioning Laura Coster that a good parent who saw the other parent barely able to breathe would call the ambulance.
Well, if it's in proper form, they'll be allowed. Again, I'm not going to pre-try the case.
E is questioning Laura Coster about whether she was ever coached by the prior defense attorney to not testify about certain things at the forfeiture hearing. I think that would make Attorney Elby potentially a witness. I don't know how it's relevant as it relates to the.
You got a comment?
So I think this is related to the one we just talked about, where if it appears that a witness was withholding information, the state should be able to inquire into that.
We will wait to see what the witness says on the stand.
Questioning Laura Coster if she had known that Mark was having an extramarital affair at the time Julie told Miss Coster she was afraid that he would kill her, and whether Miss Coster would give different advice because she allegedly knew that Mark had a motive to kill. I think that's hypothetical, and I think the court's already ruled that we'll have to wait to see.
We'll wait and see.
Okay. I think I've gotten them all now, right? I don't know if there's any others that, I think the rest of the motion on limines that I filed in November of 21 were agreed to. They're pretty standard, not allow vouching, prohibited from shifting of burden.
We got anything else we need to address from the state, Ms. McNeil?
So we do have the state's motion that was
Well,
filed.
first of all, Your Honor, we have not addressed all the defense motions. I would commend the court's attention to the state's consolidated responses to all undecided defense motions. We filed that June 27th. As you indicated previously, I think it's like an 87-page document, but the actual response is less than that. That included attachments. But on page 16 of that,
let me get there first.
Yes, that actually was the state's response to defense response.
What issue are you talking
We're
about now?
talking about the testimony that defense counsel seeks to elicit from Dr. Christopher Long about the Patricia Stallings case.
And I think Judge Schrader ruled there was no factual basis for that testimony to come in.
Yes, what happened, Your Honor, at the first trial is that defense counsel proceeded to bring in the Patricia Stallings case without having filed another acts evidence motion in advance of trial. This necessitated the court taking a break in the middle of the trial, allowing the defense attorney to voir dire Dr. Christopher Long outside the presence of the jury. And after this extensive voir dire, Judge Schrader specifically ruled that all of this was inadmissible.
Was there another acts motion filed about the defense to bring
The
in
volume from
Stallings
the
case?
courts is what he's
I think
listening
Judge
to.
Schrader ruled that
It's probably hard of
the
hearing.
information about the Stallings case as it related to a woman being put in prison and this mistake that was made was not allowed. But
I think I got this exact wording. It says the answer is no.
Yep.
For a variety of reasons, beginning with the fact you didn't even establish that he committed a mistake, made a mistake. No, I'm not going to argue about it. I made my ruling. I think the record's full. So
but the judge did allow Attorney Elby to cross-examine Dr. Long about the whiting out of information on an exhibit that was presented to the jury, and the defense would like to do that again.
about you're talking about the Stallings case?
In the Stallings case, when Dr. Long testified, he whited out information on an exhibit at the request of the prosecutor, and Judge Schrader allowed that, but did not allow the other information about the Stallings case to come in.
Hyundai Tucson versus Honda CRV. Hyundai Tucson wins every time. Get 2.9% APR financing for up to 48 months on the 2023 Hyundai Tucson. Visit your local Hyundai dealer today.
Forget the plumber. It's time to send in the Green Gobbler to handle slow-moving drains.
So I wasn't at the first trial, so.
Your Honor, first of all, if defense counsel wants to admit other acts evidence of Dr. Christopher Long in this new trial, they're obligated to bring another acts evidence motion, and they've not done that. The state is, I'm not aware of, I do have this vague recollection about this thing about an exhibit, but I believe the defense counsel is required to bring another acts evidence motion if they want to introduce that into evidence in this trial. And the state.
Let me just stop you here. Where's the other acts motion then that you were arguing?
Judge, I'm not arguing another X motion. This was the prosecutor filed a motion to exclude it, and there was a response by the defense as why it should be included. It was filed by Attorney Vishny on July 12th of 2017.
Let's give a state a chance to look at that.
All right, so for those of you that are just tuning in, jury selection for this case started this morning. Apparently, it will not be live streamed. We thought it was. Found out last minute it is not going to be. Opening statements are expected to start Wednesday morning. So right now we're watching a pretrial hearing that happened a couple weeks ago. Just kind of give you a little bit of background how the case is going to be ran. We're going to play some old clips from the original trial. We're going to show you guys the letter from the grave that is not allowed to be used in this trial. We'll give you guys a detailed kind of history of basically this entire case. And this way you guys have a kind of a full background, which will lead us up to the trial that will officially, I guess, be live streamed Wednesday.
Well, Your Honor,
it's kind of unexpected that it wasn't going to be live streamed this morning.
This cross-examination
a little odd.
On this issue. But I would need to go back
So
and review
when this hearing's done, we'll play some old clips. We'll show you guys the letter, run through some stuff. So stick around.
When we responded to this, we were responding to the issue of cross-examining him about the Patricia Stallings case generally. And Judge Schrader excluded that. But I don't have, as I'm seeing, I don't have a specific recollection of the cross-examination or the discussion on the record of this marking of an exhibit. And so I would request that I be allowed to file a written response.
Yeah, well, we could deal with it at the pretrial. Just remind me.
Thank you.
Okay, what motion does the state have that we have not decided? Did you say something, Ms. McNeil?
Yeah, so that was filed on.
Yeah, that's interesting, Denise. There's a lot of people from the Kenosha area that remember this this case, the original case. So I think this is going to be a very interesting trial. I think you're right. I think there's still some pretty compelling stuff that I honestly don't think that it's going to change a jury's mind, but we'll see.
Is that just refiling
Is
of
that the unavailable witnesses?
Right, it starts with 2 issues, and then it repeats what the state had filed for motions in limine. So the first issue that the state presented was just repeating what we wish the court to decide, which was the motions in limine, which are attached. The second issue is about witnesses becoming unavailable, and we filed last week, and the defense would have received our amended witness list that indicates who we believe is unavailable, either due to death or due to some health issues. And so I guess I would inquire of the defense if they had any objections to the people that the state designated as unavailable.
We got a response?
Judge, the witnesses that are deceased, we have no objection to them being unavailable. There's only one witness that I'm aware of that is not deceased, Ted Wote, and he is receiving medical Wote, W-O-J-T, I believe. And he is receiving medical treatment for a cancer diagnosis. I guess I'm unsure from the letter from the physician that he's unable to testify or that he thinks it would be difficult for him to testify.
Do we have a letter from the state, from the doctor?
There is. Yes, we submitted that to the defense counsel last week, and we can provide that to the court as well.
Why don't you provide me that letter? Right, what other?
Yeah, they can reuse a lot of evidence from the original thing, but the actual statements made by Julie Jensen they cannot use, and the letter they cannot use. But it sounds like, sorry about the ads, it sounds like
wilderness
testimony from
a big world made up of little moments.
Some of the witnesses that sounds like they can actually refer to the letter.
To use her testimony, even though she's not deceased.
Right. What's the defense position as to that?
I think if there is a diagnosis of dementia, that would be make a witness unavailable. We also have a witness that we believe has a diagnosis of dementia, but we're waiting to get medical.
This is the other part. There's witnesses that have serious medical issues.
That's for both sides.
So like they're saying right now, like both sides, they have witnesses that have dementia.
The defense wishes to present
So
a stipulation.
they may not be able to call those actual witnesses.
Sounds like an even trade.
So this is going to be an interesting element of
That's
this
a good
too.
question about how are we going to present this evidence to the jury? Is this going to be a reading of the transcript? Is this going
It's
to
up
be
to the lawyers.
Okay.
I'm not trying the case.
And I think that if it is the video or the recording, there is going to have to be potentially some editing because of the exclusion of evidence at this point.
We would agree that there may be some portions of recorded testimony that would need to be revised or excluded. And the state's prepared to do that. What I'd propose is this, that the parties between ourselves look at the transcripts of the testimony of the witnesses that we intend to present who are no longer available, and then we'll indicate what portions of that examination we deem to be inadmissible or we object to. The parties should be able to exchange that, and if we come to an agreement, then the court won't need to be bothered with it. We'll only address to the court the issues that we can't agree to.
Sounds
That's
good.
very good advice. That's what we did in the civil trials when we had testimony from doctors.
Yeah,
The
this
lawyers
is
worked it out, and they agreed to
this
what
is
was
definitely
not
going to be
gonna
really
read to the
interesting.
jury.
And that may
99
change
out
the
of 100
outcome of this
cases,
trial, which, you know, it could lead
Okay,
to a
what
lot
do
of
we got next?
backlash in the community.
So our final portion of that was just, we intend to notify the parties about the use of the defendant's book by the final pretrial date in December.
And which portions of the interview transcript?
You're going to provide that information to the defense by the pretrial date, correct?
And actually, regarding the interview transcript, we did file what we intended to use, and that was in, let me get the date on that.
And you're going to provide that too to the defense?
We've already provided it to them.
Already provided that, all right.
So there's a lot to dig through so that the defense knows what I'm referring to. It was on March 31st of 2017 that we filed that.
So it's the same. It's not changing from then.
That has not changed, and so I think we just need to confirm that we still feel the same about what should be used.
All right. What's next from the state?
So then, Judge, it's just following is the motions by the states. That's part of the same filing. We have the first 8 motions have to do with testimony that apparently was at least attempted to be elicited at the last trial regarding mental health history and some, I would say, other act type situation regarding
he's been in
Jensen.
custody
And so the
this
state
entire
has,
time.
specifically moved to exclude this evidence from this trial, given that it was brought up at the prior trial. And so if the court wants me to go through one by one, I can do that. However, the court would prefer.
Has the defense responded to that?
Judge, most of this stuff was allowed in at the first trial.
All right.
So I can tell the court which ones I don't
I
have.
thought we said Judge Schrader made the correct rulings.
Well, Judge, we are bringing this up because we do not think that these particular things that were questioned at the last trial were admissible as relevant. And, you know, part of the issue is a lot of this happened.
She did. You're right, Arm. She did die in 1998. Case didn't go to trial for years later. He was convicted originally in 2008. And then for the next several decades, this case has been back and forth through multiple courts, higher courts. And it's finally been ruled that he deserves a new trial, and the original letter from the grave is not to be used, nor are Julie's statements.
For me, then, so then I have it as part of the record.
So we'll go through the letter after this. We're just kind of playing a pretrial hearing that happened a few weeks ago. Kind of get you guys up to speed and acclimated. Some people don't know about this case. Some people don't know all the details. So we're playing this to get you guys kind of up to speed since the jury selection is not being live streamed, unfortunately. We'll play some clips from the original trial. We'll show you guys the letter. We're going to go through kind of a detailed history of the case. This way you guys have all the knowledge. We're downloading the original criminal complaint. So we'll kind of go through, we'll show you guys that. We'll go through that with you guys.
And just so the court's clear, Attorney Vishny did respond to these motions.
So that's what I'm doing right now. I'm kind of getting this
You got
all
an agreement of what's coming in and
ready for
again,
after this.
If it's relevant, it's coming in. Anything else from the state?
So your message said you wanted to talk about insurance? I said I want you to talk about insurance. Most people know that.
I do have one issue. If the parties want, I don't know if it's going to be an issue. And Mr. Jambo, you could probably respond. Was there an issue as to the termination of Dr. Maureen Levin?
Yes, Your Honor. The defense had sought to cross-examine Dr. Mary Mainland about Dr. Lavin's termination of employment. Of course, Dr. Mainland was not here at the time that Dr. Lavin was terminated. The state believes that any testimony regarding any information regarding Dr. Lavin's termination from employment is not relevant to this case. Dr. Lavin was the medical examiner for Kenosha County at the time this case was on December 3rd, 1998. The date that Julie was killed, but she testified at the preliminary hearing. But while preparing this case for trial, she refused to answer questions in my office about her, whether or not she was board certified. We knew she was not board certified. We were simply asking her questions about this, and she said she wasn't going to answer it. And I said, well, you understand that when you go into a courtroom, if you refuse to answer questions that are put to you in defiance of the judge's order, you might leave that courtroom in handcuffs. And
no, I don't think he testified in the original trial.
when you're sitting in the district attorney's office and he's asking
If Denise is still here, she
you
might.
are
I didn't watch
answer
the
those
original
questions
trial.
as well. And if you don't, you're
I wasn't even living in the state of Wisconsin at the time.
And as a consequence,
I was
she
still
terminated.
98.
It had
Shit, I
nothing to do with her opinions
graduated high school a year
concerning
earlier.
Any of the evidence in this case, it had nothing to do with her theory of what or her prior testimony.
I don't think he testified.
Manner of death in this case. It was simply because she had not become board certified and she refused to answer that question.
So she never testified in Jensen 1, right?
She did not testify in the
And
trial.
Dr. Mary Mainland testified?
Yes, Your Honor.
And she was obviously the medical examiner for Kenosha County at the time, or from another county?
She was our medical examiner at the time of the Jensen trial.
So what would she know about the termination of Dr. Levin?
Well, as she indicated, she really didn't know that much about it. And she had heard things about it, but she wasn't here at the time that Dr. Levin had been terminated. I think what the defense counsel was trying to elicit from Dr. Mainland was that she was intimidated into rendering these opinions by the district attorney because the district
And
attorney...
that was you?
Yes, because the district attorney had gotten the previous medical examiner terminated. But she was not terminated because she refused to agree with the prosecutor's theory of the case. In fact, the prosecutor's theory of the case has always come from the medical examiners. It's not the other way around. But she was terminated because she refused to answer questions pertaining to whether or not she was board certified. It has nothing to do with the development of the evidence in this case. So it's completely...
Did we ever find out if she was certified or not?
She was not board certified. That's why she refused to answer the questions.
But Judge, I think the concern is that as it relates to the cross-examination of Dr. Mainland testified that she was aware of some of this information. Maybe not everything that Attorney Jamboy said, because she wouldn't have had that information unless Attorney Jamboy told her that information. But she was aware that there was an issue as it related to the Jensen case and her findings that caused Dr. Mainland was aware that there were issues with Dr. Levin and her findings in the Jensen case, or her testimony in the Jensen case, that caused her to be terminated from her employment.
Did she testify to that in front of Judge Schrader?
She testified that she was aware that that Dr. Levin was terminated.
While you're looking at those other transcripts, see what she said in Jensen.
Well, Your Honor, I can tell you this. The whole theory of the cross-examination of Dr. Mainland was to suggest, plant in the jury's mind, that Dr. Mainland was somehow intimidated by the prosecutor into rendering the opinions that she rendered in this case. Contrary to what defense counsel just said, there was nothing about Dr. Levin's testimony.
That's what I'm saying. Get the transcript and let me take a look at it.
Okay.
So remind me, that's another...
Yeah, they have kids.
All right. I'll ask the state. We got anything left?
So I think there's one other point in our motion in limiting.
Oh, yes. The state had filed a motion to prohibit the defendant from introducing evidence concerning, in fact, introducing the letter that I had written on June 18th, 2003, and sent to defense attorney Craig Elby. The state objected to it as it being irrelevant, hearsay. And the defense sought to introduce the letter under a variety of theories, and the state will then address that. And we did so on, what was the page of this document? The document is document number 1487, and it was filed March 28, 2022.
Get to that document 1487.
Yes, Your Honor.
For the record, right now, there's 1,515 documents.
And Judge, this is something that was specifically ruled on by Judge Schrader And what he said is he was going to allow the letter to come in through the expert. Otherwise, basically, Attorney Jamboy would be a witness in the case because it's a prior inconsistent statement.
And Your Honor,
What expert are we talking about?
Dr. Long.
Well, how would Dr. Long be in a position to testify about a letter that the prosecutor wrote to Craig Elby? There's no foundation for Dr. Long to be testifying about that letter.
Let me just stop you. Did he use the letter at any time to form any opinion?
Dr. Long?
Yes.
He never saw the letter, Your Honor.
The letter was a specific statement by Attorney Jamboy as to what Dr. Long was going to testify to at the trial.
Okay.
Dr. Long did not testify consistent with that letter, making the letter from Attorney Jamboy to Attorney Elby an inconsistent statement of a party opponent. This was argued at great length before Judge Schrader, and Judge Schrader ruled that it was an inconsistent statement and the letter could be used. And he basically said that he was going to allow the letter in so that Attorney Jamboy himself would not be a witness, because otherwise Attorney Jamboy would have to testify as to the prior inconsistent statement, which would make him a witness in the case. So instead of making Attorney Jamboy a witness, Judge Schrader allowed the letter in as cross-examination of Dr. Long.
And the state opposed that at the time, Your Honor, and none of the criteria that apply to the admission of prior statements by prosecutors, none of those criteria were met in that case. But
Attorney Jamboy conceded that some of those were met.
Well, I concede, Your Honor, that I wrote the letter and that the letter was in error, that I wrote that letter, that I committed an error when I wrote that letter. Then when, let me finish, counsel. Then at the time of the forfeiture hearing, Dr. Long did not testify in a manner which was consistent with the content of my letter. At the time of the trial, he did not testify in a manner which was consistent with that letter. So the fact that the prosecutor made a mistake in, what was it, June of 2003 is not relevant, was not relevant at the time of this trial in January and February of 2008. And it's even less relevant now. So the error that I'd made in that letter was based upon a letter that Dr. Long had written. And that the state agrees that Dr. Long's letter is admissible. Dr. Long's letter made reference to the content, the amount of ethylene glycol in Julie's blood and Julie's stomach.
It's happened in all the cases out here.
Described the ethylene glycol in her stomach as a large amount when it turns out it's a half a teaspoon of ethylene glycol in her stomach.
We saw it during the Rittenhouse trial. We saw it during Theo Edgecombe trial.
So this was all.
We actually, with the Theo Edgecombe trial that happened out here in Milwaukee, because of a mistake that the court made with the camera system showing jurors, we reported that, and we actually got a 50-person jury panel removed
in 2003
because of that.
Does not address the issue of it makes me a witness in the case. And I don't wish to be a witness in this case because I'm prosecuting the case along with.
So for us here in Wisconsin, it's odd that jury selection is not televised.
I don't think that this letter is admissible, and it doesn't fit any of the criteria for admission. It is a statement by the prosecutor, but it was never made in a courtroom. It was never made in an opening statement. It was never made in a closing argument.
Right. They just don't show faces.
It was made in a letter to a defense attorney months in advance, in fact, years in advance of the case going to trial. It's just not relevant. It has nothing to do with the facts of this case today.
I'll give you a brief response from the public defender.
I mean, honestly, I'm fine with it not being
Judge Schrader considered
aired. I don't like playing those anyway, just because there's too much detail about jurors that gets publicly talked about, even though they don't show jury.
It was an inconsistent statement because it went from a very large quantity.
But yeah, I mean, like the Theo Edgecombe trial where we had a 50-person jury panel removed, it
agent of the state.
You know, I mean, there were like county clerks that were on that original jury panel. And I mean, very easy to be able to identify people.
A half a teaspoon, which is what Dr. Long later testifies to.
You know, there's trials that we've covered where I've actually muted certain questions and answers because it identifies people. You know, and then obviously our viewers get pissed off about that. But
of a defendant or a witness.
when they
Judge
name
Schrader
like
found
the
it ultimately
witnesses, like they
seems
did
to
in
that-
the
to me
the
that Mr.
Rittenhouse
Albee has the right to
trial.
argue to the jury that this is circumstantial case
You
tending to
know,
show
I
that
mute
Dr. Long made
that,
some
even
faulty
though that's a matter
information,
of public
which would
record.
tend to raise
But
doubts about the accuracy of some of the reports in this case. That was number 2.
you know, we
Third,
get
the trial
viewers that
court
get
must, in
angry
a
that I
hearing
mute
outside the
that
presence of
stuff.
a jury, determined by
So
a preponderance of the
I'm
evidence
fine
that
with
the
it. I don't
inference
really
the
care,
prosecution seeks to draw.
but
In this case,
we just
the defense
expected that
seeks
it
to
was
draw
going to
from the
be live
inconsistency
streamed.
is a fair one,
Apparently, it's
and that an
not. So
innocent explanation does not exist. Judge Schrader stated, "It strikes me that this isn't a question of an innocent explanation or anything. This is a suggestion
but
that
yeah,
there
I mean,
exist
there's hundreds
various
of trials that
circumstances
have
consisting of your letter and
live
Dr.
stream
Laban's
jury
testimony, because Dr.
voir
Laban
dire.
also relied upon this information from Dr. Long. At preliminary examination, there are circumstances which might suggest to the jury, and I'm not saying that I conclude this or I believe this, but the defense would be entitled to argue to the jury that the circumstances suggest that perhaps Dr. Long was a
I'm
little
subjective.
careless in things that were stated to the people. And that strikes me that that would meet all 3 tests. Judge Schrader further found that crossing Dr. Long
I just don't like it. I mean, look at what happened to me for the Rittenhouse trial when they named me as a potential witness, right? I mean, a lot of harassment and threats started coming in. So
on the 3rd. So my ruling is a letter could be presented as a statement against interest by the government.
Did the letter then come into evidence, and was it used?
I mean,
when
I don't
defense
even like when the
cross-examined
jury
Dr.
list,
Long?
you know,
Give me
after
that
like the
transcript
verdict and all the
portion
stuff,
again,
and
and I'll
then
make a ruling
you know,
at the first
after so much time, the
January
jury
10th, 2012,
names become a matter of
284.
public record,
I'm sorry, it's document
right? And then that's when
27-4.
media goes out and tries to contact them to see if there's,
Different pages in here, sorry.
you know, if they want to give interviews. And I don't even like when that happens. I get it; it's got to be public, but
that's why that's long.
I don't like when that happens.
Okay. It's the January 16th.
And that's just my own
08.
personal. I mean, I think the Brooks jury, I think that's public now. I still haven't even filed for that just because.
It was Dr. Long's testimony transcript.
I don't know.
January 16th, 2008. Oh man, I do. Hold on 1 second, Judge.
But yeah, if you guys are just tuning in, we thought that the jury selection voir dire was going to be live streamed. It apparently isn't. Opening statements are expected Wednesday morning, so we'll definitely live stream that. Should the court go live tomorrow morning, we'll go live. We're playing an old pretrial hearing. This will kind of catch you guys up to speed on some of the last minute decisions. We're going to play some old clips from the original case. We're going to show you guys the letter that is not allowed to be used in this retrial. We'll go through a history of the case. We've got the original criminal complaint, so we'll pull that up for you guys. You know, we'll read that to you.
Cooking soul food with my family is very
Bear with
important,
the,
but I started.
Bear with the ad, sorry. So yeah, we'll show you guys the original criminal complaint. We'll show you the letter, kind of go through a whole little history. And for those of you that are tuned in, this will get you guys really caught up to speed with what's going on, what happened in the first trial. And then again, this trial is expected opening statements Wednesday morning. So we'll see what happens.
I'm going to have to, I have a number of different transcripts because some were attached to the appellate briefs.
And then obviously during the actual trial, you know, I'm not going to be talking like I am now. This is obviously some older footage from a few weeks ago. So during the actual trial, I'm not going to talk. We'll talk during breaks. During breaks, you know, we'll show you guys some clips of things that happened in the old case.
All right, why don't you just
Any questions that you guys had during, you know, during the stream, we'll address those questions on breaks and things like that.
So there's no ex parte communication.
Your Honor, why don't I do
If you're
this?
watching on YouTube, make sure you guys are subscribed so you know when we go live. If you're watching on
Two exhibits,
Facebook,
one
be
is
sure to
Dr.
like and
Long's
follow
letter,
the page.
and which the state agrees that Dr. Long can be cross-examined or examined and direct cross-examined about the letter that he wrote. And then we'll pull up my letter that and we'll mark
If you guys
that
are
as
new to
exhibit
the platform in general, so we're an independent investigative journalism company.
The state's response
Focus on a lot of civil rights issues, corruption within systems. Our investigations generally take, you know, a few months. We have the most compiled footage and
the state
documentation when it
agrees
came to
that
the
Dr.
Kenosha
Long can be
riots.
cross-examined about the letter that he
So that
wrote
can
to
all
the
be
state
found on our
concerning
YouTube
the
channel with body cam
circumstances surrounding Julie
footage,
Jensen's
footage
death.
from inside the
And
Bearcats.
in that letter, he indicated that there was a large, I think he said a large amount or large concentration.
Articles can
of
be read on our
alcohol,
website,
something like
Never.Stop.Voices.com.
3,200 micrograms per deciliter.
A lot of information on there.
1,280 micrograms per deciliter in her stomach. The state agrees that Dr. Long can be cross-examined about his letter. The state objects to Dr. Long being cross-examined about my letter to defense counsel because Dr. Long never saw that letter. He had nothing to do with writing that letter. That letter was my letter, and I don't wish to be a witness in this case. And I don't think that the kind of what Judge Schrader did at that time reflects the correct application of the law to the facts. Now, the state had not known that defense counsel was going to be seeking to admit my letter into evidence until defense counsel started cross-examining Dr. Long about it. So this objection and the court discussion all occurred kind of, you know how things come up in a courtroom. And there was not the opportunity for the trial court to address this in advance of trial. Well, now you will be given that chance. So I would commend to the court's attention the letter that was written by Dr. Long, my letter that was then written to.
Just provide that to me prior to the pre-trial.
And I wish to
Both
emphasize,
letters.
and I wish to emphasize, Your Honor, that Dr. Long testified extensively about his letter, and was cross-examined extensively about his letter, and the state has no objection to that. I just object to my letter coming into evidence.
Give me both letters. You give me the transcript. I'll make a decision.
And Judge, just to be clear, like the letter that Dr. Long wrote, there's no question about that. That's his letter. But what the argument was, and Judge Schrader took the time to listen to this, is a statement of a party opponent. So if we can't cross-examine Dr. Long on the letter itself, we have to bring in the witness who took the inconsistent statement, and that's Attorney Jamboy.
All right. Give me the transcript portion. All right. What do we have left? Hopefully the answer is nothing.
Yeah.
So a little bit longer of this pretrial hearing, and then once again, we're going to show you guys the letter. We'll go through the original criminal complaint, play some other older clips from the original trial.
We've covered everything.
We'll give you guys a full background here.
Written order for everything that was decided today. I've given you briefing times. I want
so stick around for that.
Letters to make the decision. We do have a final pre-trial.
Hit that thumbs up on YouTube if you haven't already. On YouTube, there's a lot of links that are coming through the chat. It'll bring you to our website, our Facebook page, our Patreon that we're trying to build because YouTube shadow bans us and pulls our streams down a lot. So we're trying to build up a brand new Patreon that we just started so we can do some live streams and some exclusive content over there. You become a member on YouTube for some exclusive member-only content.
Judge, how long did
If you want your comments highlighted on YouTube, you can send in super chats. There's some donation links. Any donations, things that you guys send in, Venmo, Cash App, whatever, super chats. That money is used towards filing open records requests, suing police departments for records when they want to play silly games.
You guys got 45 minutes.
Cost involved in all of that stuff, so it helps.
Much longer than that, Your Honor. Considering the number of issues that are going to be addressed, I mean, even the issues, just the transcripts of the testimony.
Choose your words carefully.
So my company, Never Stop Media, we have by far the most content, documents, videos, all of that when it comes to the Kenosha riots. You can find that on our YouTube channel. There's tons of playlists, body cams. You read our articles, things that we've exposed. We're about to be
Thank you. Have a good day.
We're about to be releasing an article here shortly about the Kenosha curfew, what actually happened, the truth behind that. We'll also be on the lookout for that.
We need a little break. Tell them we'll take them.
It'll be in the morning.
Okay, I guess it won't take all day, so I have a feeling for this afternoon. I see something.
Therapy for me, I think when the
Do you have any questions for me or? Okay. All right.
So we'll stop it there. It's pretty much done. All right, so let's pull up some stuff because I know you guys want to see some stuff. Let's get into it. All right, so while we were watching that, I posted a bunch of stuff on Facebook without you guys knowing. So this is the what happens to death benefits when the beneficiary goes to prison for murder. They don't go to that person. All right, so this is the letter that was originally used in the original trial. This letter, so the higher courts said that this letter cannot come in. Basically, the history around this letter is that Julie had written this letter and then sealed it up and gave it to her neighbor, basically, under the premise of, should anything happen to me, open this sealed envelope. And basically, my husband, has done something horrible to me. So she directed this letter to a Pleasant Prairie police detective named Ron Kosman. So it says, I took this picture and am writing this on Saturday, 11/21/98 at 7 a.m. This list was in my husband's business daily planner, not meant for me to see. I don't know what it means, but if anything happens to me, he would be my first suspect. Our relationship has deteriorated to the polite superficial. I don't know what that means. I know he's never forgiven me for the brief affair I had with that creep 7 years ago. Mark lives for work and the kids. He's an avid surfer of the internet. Anyway, I do not smoke or drink. My mother was an alcoholic, so I limit my drinking to 1 or 2 a week. Mark wants me to drink more with him in the evenings. I don't. I would never take my life because of my kids. They are everything to me. I regularly take Tylenol and multivitamins. Occasionally take OTC stuff for colds, Zantac, or Imodium. Oh, over the counter. That's what that. Have one prescription for migraine tablets, which Mark used more than I. I pray I'm wrong and nothing happens, but I am suspicious of Mark's suspicious behaviors and fear for my early demise. However, I will not leave, and this is presumably the 2 kids' names, my life's greatest love, accomplishment, and wish. My 3 Ds. Daddy, Mark, and then it's, presumably the kids' names. So that is the letter. So it is interesting that she's in. I don't know, man. This is tough, right? So we know that they're going to use the internet because allegedly he was surfing the internet on poison and how to make poison things look like unaliving a person. Right? We got to use that verbiage because we can't say certain words here. On how to unalive somebody. And it's interesting that she writes in her letter that Mark is an avid surfer of the internet, basically telling police, like, go look at the internet. That's interesting. There's a few things in this letter that really kind of stand out. So the allegation is basically, from his perspective, is that she intentionally wrote this letter. She unalived herself, and then framed Mark for her murder. That's what defense has put on. He was originally convicted because of this letter. Obviously, some other damning evidence used in the original trial, but this letter kind of sealed his fate. But it's definitely interesting. I don't know. What do you guys think? What are your thoughts on the letter? It's kind of interesting there. And then we'll pull up the original criminal complaint. So we posted this stuff on the Facebook page, so you guys can go read this stuff there. So I was posting this actually while we were watching that pretrial hearing. All right, so this is the original criminal complaint. So this says, District Attorney Robert J. Jamboy, who's now back on the case, helping prosecute this case once again, being first duly sworn on oath, says that on December 3rd, 1998, at the village of Pleasant Prairie in Kenosha County, the defendant did cause the death of another human being, specifically Julie C. Jensen, with the intent to kill that person, contrary to section, and it gives a statute, first-degree intentional homicide, a Class A felony punishable by life imprisonment. On December 3rd, 1998, at 4:35 p.m., Sergeant Dan Riley and Officer Laura Hoffman of the Pleasant Prairie Police Department arrived at the home of Mark and Julie Jensen at 9020 Lakeshore Drive. Upon entry to the home, they found the defendant, Mark Jensen, standing in the kitchen trying to use the phone. The defendant appeared to be visibly upset. When Sergeant Riley asked the defendant where the victim was, the defendant pointed down a hallway. Sergeant Riley then entered the bedroom at the end of the hallway, where he found the body of Julie C. Jensen. Julie was lying in bed on her stomach with her face partially buried in a pillow. During the 3-week period preceding her death, Julie Jensen had told a variety of people who she trusted that her marriage was in the toilet, that she would be seeking a divorce from her husband, and that she was concerned that her husband was going to try and kill her, possibly with poison. She said if anything were to happen to her, it would not be unaliving, and they should suspect the defendant in the event of her death. Forensic toxicology reports show that Julie Jensen died as a result of ethanol glycol poisoning. Furthermore, the tests conducted on her stomach contents, kidneys, blood, and urine show that she received at least 2 doses, and the final dose was administered just shortly before her death, when she would have been unconscious or at least too weak to move or get out of bed herself. On the day of her death, despite a very thorough search, the police found no traces of ethanol glycol, most commonly used as antifreeze, anywhere in the Jensen bedroom, residence, or garage. On Wednesday, November 25th, 1998, Julie Jensen was serving as a volunteer parent in her son's 3rd grade class at Southport School, which was taught by Teresa DeFazio. Ms. DeFazio described a conversation that occurred that day between them. This is an excerpt from the conversation. It says, when I coaxed her, she told me how she was afraid her husband was going to kill her last weekend. When I asked her why she thought such a serious thing was going to happen, she explained why. She had found a paper listing things to buy in her husband's stuff. She said it listed syringes and names of drugs on it. Then she said that she thought he might try to kill her with a drug overdose and make it look like a unaliving. I asked her why she thought he would do this. She said that there were other things she couldn't explain. She also wondered aloud if the drugs were for himself, but she didn't ever see him taking drugs, so she didn't think that was the reason for the list. One other time she had mentioned that it bothered her how every time she walked into the room when her husband was on the computer, he always turned it off or covered it quickly. She asked him why once, but he said he was doing business stuff and he was done. Thaddeus, I don't know how to say this last name, Julie Jensen's friend and next door neighbor, reported about 2 weeks before Julie's death, Julie told us that something was going to happen. She suspected Mark was trying to poison her. Julie stated Mark would offer her some drink and Julie would not drink it because she thought it was poison. Julie gave me an envelope with my name on it. Julie asked that if anything happened to her to give the envelope to the police. I did not know what was in the envelope when I handed over the envelope to the police after Julie died. On the weekend before her death, the Sunday before, I saw Julie and she stated to me that she was afraid that Mark was putting poison in her food or drink and she did not eat all weekend. Julie was shaking and crying. She was in bad shape. Julie also stated Mark would call up things on the internet about poisoning on the internet and he would leave it on the screen for her to see. Some of the things were undetected poisoning that was on the computer. Thaddeus turned over to Detective Sergeant Paul Ratzberg the sealed envelope that had originally been given to him by Julie Jensen. Detective Sergeant Ratzberg opened the envelope and found the following letter. Pleasant Prairie Police Department, Ron Kosman or Detective Ratzenberg. And so that was the letter that we just showed you guys. JK, did they use the purchase list in the initial trial? I'm sure they did. I don't know. I didn't watch the original trial. I was too young. All right, so we read the letter. So that's what this next part of the criminal complaint says. The envelope and the letter signed Julie C. Jensen were submitted to the state crime lab along with known writing samples from Julie C. Jensen. Jane A. Lewis of the questioned documents section of the state crime lab concluded, based on the exemplars submitted, it was determined that Julie Jensen wrote this letter that Mr. Again, I don't know how to say this last name, had turned over to the Pleasant Prairie Police Department. On December 4th, 1998, pathologist Michael Chambly performed an autopsy upon Julie Jensen's body. February 4th, 1999, Dr. Chambly produced a preliminary autopsy report and was unable to determine a cause of death. Subsequently, Kenosha County Medical Examiner Maureen Labin had additional toxicological studies performed upon the kidneys, blood, and gastric contents that were collected during the autopsy on Julie Jensen. These additional toxicological studies, try saying that word 3 times fast, revealed that there was significant formation of oxalic acid crystals in the kidneys of Julie Jensen. Furthermore, tests performed upon the blood sample by Dr. Christopher Long, a forensic toxicologist at the St. Louis University Toxicology Laboratory, revealed the presence of ethylene glycol at 55 micrograms per milliliter in the blood, ethylene glycol at 720 micrograms per milliliter in the urine, and 3,094 microgram per milliliter of ethylene glycol in the gastric contents. Dr. Levine, I don't know, then reviewed this entire case study with Dr. Jeffrey M. Jensen, different spelling, of the Milwaukee County Medical Examiner's Office. Dr. Jeffrey M. Jensen then provided the following conclusion. It is my opinion to a reasonable degree of medical certainty that Julie Jensen died as a result of homicidal poisoning with ethylene glycol. I arrived at this conclusion based on the totality of the investigation in additional to the clinical description of systems, the gastric contents, toxicology results, and microscopic slides demonstrating the classic findings of renal, tubular, and intravascular crystals. The state had also consulted with Christopher Long, a forensic toxicologist associated with the Department of Pathology, the Forensic Toxicology Laboratory at St. Louis University Health Sciences Center. Dr. Long concluded there's a lot. Ethylene glycol was the cause of death in Miss Jensen. The pathology shows crystals in the kidneys, and the toxicology demonstrates ethylene glycol. This compound was identified in the blood, and large amounts were found in the stomach contents. There is no other reasonable explanation for Miss Jensen's death. Miss Jensen did not die from a single administration of ethylene glycol. The concentration in her blood was low, but the tissues had crystals. These crystals demonstrate that she survived the initial phase or phases of ethylene glycol poisoning. The stomach having a large concentration of ethylene glycol demonstrates an acute ingestion at or near the time of death. The crystals in tissues define the first dose or doses at more than 12 hours earlier, and the stomach concentration defines the second or final dose at her death. The autopsy testing shows that there were at least 2 doses of ethylene glycol, and this is further supported by her history. This appears to be a homicide for the following reasons. The ethylene glycol was not present in the house. Her stomach contained significant amounts of ethylene glycol, showing her death occurred at or near the time of administration. Miss Jensen would have been too weak to drink the volume of ethylene glycol found in her stomach at autopsy without help. Miss Jensen would have been too weak to hide the ethylene glycol after her final dose. Multiple doses were administered. Her reports to the police regarding the fear for her life from her husband, her letter 10 days before her death. This is a case of ethylene glycol poisoning with a fatal result. The chemical was administered at least 2 times prior to her death, which is inconsistent with an unaliving. Detective Sergeant Paul Ratzberg reports that he obtained consent from the defendant to search the entire residence and seize whatever evidence was necessary to conduct an adequate investigation in this case. Among the items seized from the defendant's residence was the defendant's computer. Detective Sergeant Ratzberg sent the defendant's computer to the State Crime Lab for analysis by computer evidence technician Brad W. Haller. Brad W. Haller reported that he was able to recover internet communications between the defendant and his apparent girlfriend, Kelly Labonte. Furthermore, Brad Haller was able to recover Mark Jensen's hard drive, the internet browser cache files. Very personal internet email communications between the defendant and Kelly Labonte. Were first observed on September 3rd, 1998. The defendant replied, apparently from his home computer, "Thank you. I wish I hadn't been so tired. So little sleep the previous nights. Was just hanging out. Definitely lucky. Got a few looks and question about being in St. Louis. Cute, all covered. Then Ron called. It was about Columbus. Just funny the way it flowed. Hey, came in this morning and my blinds were up, and I do like those knobs. Idly, cheers." Kelly Labonte responds, "When I heard Marsha say you were on the phone for Ron, I was all ears, but not too concerned. It was funny, though. You have knobs on your blinds." Jensen replies, "Wouldn't mind knobs on my blinds. Would prefer cheeks on my desk. Cheers. Did you smile?" Labonte responds, "If you continue to be a good boy, maybe you'll get what you wish for. I would enjoy participating. Yes, I smiled. I always smile when talking with you." According to the internet access records recovered from the defendant's hard drive, the defendant began researching methods of poisoning on October 15th, 1998 at 6:07 p.m. when he examined a site entitled Botulism in Low-Acid Canned Foods. On October 16th, 1998 at 4:10 p.m., the defendant accessed a site regarding mercury fulminate. This site described the method and ingredients employed to create mercury fulminate, which is a primary explosive in the fabrication of detonators. On November 9th, 1998 at 6:40 p.m., the defendant accessed on Yahoo a site entitled Physician-Assisted Unaliving. On that same date at 6 p.m., the defendant accessed a site entitled Toxicology. On November 29th, 1998 at 5:21 a.m., the defendant accessed a site entitled SierraAntifreeze.com. On December 2nd, 1998 at 6:23 a.m., the defendant accessed a site on the internet entitled Ethanol Glycol, which, among other things, described the effects and stages of ethylene glycol poisoning. On December 2nd, 1998, at 6:36 a.m., the defendant accessed an additional internet site also devoted to the subject of ethylene glycol and its toxic effects. On that same date, at 10:47 p.m., the defendant accessed a site entitled Antifreeze Poisoning. March 19, 2002, Kenosha County Medical Examiner Maureen Lavin, a forensic pathologist, prepared a preliminary autopsy protocol. Dr. Lavin concluded that Julie Jensen dies as a result of ethylene glycol poisoning and that the matter of death was homicide. Your complainant is a Kenosha County District Attorney and has knowledge of the above alleged facts from having reviewed the reports of Detective Sergeant Paul Ratzberg, Sergeant Dan Riley, and Officer Laura Hoffman of the Pleasant Prairie Police Department. Your complainant considers the reports of these law enforcement officers to be reliable as they were prepared during the normal course of their duties as law enforcement officers. Further, your complainant has reviewed the statement of Teresa DeFazio. Your complainant considers the statement of Teresa DeFazio to be reliable as she purports to be an eyewitness to the facts alleged within her statement. Your complainant has also reviewed the statement of Thaddeus, whatever the name is we can't pronounce. Your complainant considers the statements of Thaddeus to be reliable as he purports to be an eyewitness to the facts alleged within his statement. Your complainant has also reviewed the reports of Dr. Jeffrey Jensen, again, a different Jensen, Milwaukee County Medical Examiner, Dr. Maureen Lavin, Kenosha County Medical Examiner, and Chris Long, forensic toxicologist associated with the Department of Pathology at the Forensic Toxicology Lab at St. Louis University Health Sciences Center. Your complainant considers the reports of the foregoing professionals to be reliable since they purport to be eyewitnesses to the facts alleged within their respective reports. Oof. All right, so that is the original criminal complaint. Denise, who is the Nightbot? So the Nightbot is it's basically like a computerized moderator. So we have mods, but they're not always on. So this is like a computerized mod that allows us to set up, chat comment parameters, links, things like that. So that I can focus on 18 other things. And, if I don't have moderators in here, this Nightbot, just kind of a computer generated moderator. That's what that is. So our chat parameters are set pretty high on YouTube and Facebook because we do get some trolls in here. But there are some parameters that we didn't set up that's just automatic with the Nightbot. So be careful with emojis, be careful with caps locks. The Nightbot we've seen has a tendency to be kind of rude. That's not us. But the Nightbot will time people out on comments. And we've had people basically banned from comments for 10 minutes. So just be careful with certain commentaries. Nightbot is a little bit sarcastic as well. So, all right. So, we showed the letter, right? That is posted up on our Facebook page, NSM News Updates. If you guys want to like and follow the Facebook page so you can see that. Here's a copy of it again. So you can see that. You can share it all around social media, get crazy with it. And then the original criminal complaint that we just read. So that's also on our Facebook page, NSM News Updates. So you guys get crazy with that. Share that around. Yeah, JK got banned for like 10 minutes in comments. But yeah, again, some of the parameters with the Nightbot we don't control. Other things we can, but the Nightbot is kind of an asshole. So almost a bigger asshole than I am. All right, let's watch some old clips. So once again, if you guys are watching on Facebook, be sure to like and follow the Facebook page. If you're watching on YouTube, be sure to subscribe so you know when we go live. If you guys are new to our platform in the company, so the company name is Never Stop Media. Our YouTube channel is Never.Stop.Voices. Our website where we write our articles is Never.Stop.Voices.com. We're an investigative journalism company. We pick and choose topics to cover. We do primarily focus on civil rights issues and corruption within systems. We have hundreds and hundreds of videos on our YouTube channel, especially surrounding Kenosha. I was one of the live streamers that was out there. We're one of the journalists that's ripping apart Wauwatosa Police Department. Kind of known for a lot of things. When we do live streams, I am a bit abrasive. I do cuss. If you don't like that, I don't know, too fucking bad. Go read the articles. We're a bit more polite in how we write our articles. Yeah. So this trial, unfortunately, the jury selection is not going to be live streamed. It's a little odd for Wisconsin to not do that. Opening statements are expected to start Wednesday morning. Should the court go live tomorrow, we will go live. If not, plan on us being live on Wednesday. So once again, we have the letter on our Facebook page, NSM News Updates. You guys can read it for yourselves there, as well as the criminal complaint. So we'll get into some old stuff. So we'll start here. So this is the original judge was Judge Bruce Schrader. You guys may recognize the name from the Kyle Rittenhouse case. And this is a clip of Schrader talking about the original Mark Jensen thing. I'm going to play a few clips.
I've talked about inaccurate things out on the media. And one of the things that I've read over and over and over again is about how I messed up the State against Jensen case, which is now pending downstairs. Actually, I had it 100% correct in the first place. I ruled that the disputed matter was testimonial evidence that had to be confronted. And your office appealed. This is 20 years ago. And it was fine. It was a big issue. It was a big case. And the state Supreme Court reversed and said, no, we're going to adopt a new rule that is to be applied in this case about waiver and forfeiture. And so it came back, and I said right in the record, this is going to get reversed again, because it was an unsound ruling, unanimous. I hate to say that about the Supreme Court, but it's true. And of course, that has proved positive. So I tried the case according to the way the Supreme Court told me to try it. And that was 20 years ago. The man is still in prison. And the case has again been reversed because of the evidence that the Supreme Court told me to admit. I don't want to mess around with confrontation issues. I can't let you present evidence into this record, which is barred by the confrontation rule. And you're asking me to let this just run while this man is making descriptive materials to prove the state of mind of the accused? That doesn't make any sense to me at all.
So that that was actually so that clip is actually from the Kyle Rittenhouse trial, when they were trying to admit into evidence the CVS incident with Rittenhouse, where he's caught on a recording watching some looters coming out of a CVS. I think it was in Illinois. And he makes a comment about how he wishes he had his rifle because he'd start firing rounds into them. And the district attorney, Binger, was trying to get that video into evidence during the Kyle Rittenhouse trial for state of mind. That basically, like, this was a premeditated situation surrounding Rittenhouse, and he used this whole Mark Jensen case to describe that. Schrader is not happy that this case has bounced back. He's a bit irritated. All right, so we'll play. So this is a portion of the interrogation. So there's some interesting stuff here. So we'll play this portion.
Oh. You need to find out what happened here. Oh. I did not do anything to hurt her. There was a question between myself and the kids that morning whether or not to call an ambulance. Her breathing was funny. She could hardly get out of bed. I mean, it was a god-awful situation.
Here in your statement, Wednesday, December 3rd, Julie, you could hardly move. Your 9 p.m. told me that she was fine and she wanted to commit suicide. And on Wednesday morning, Julie asked me not to call anyone, meaning not to call her help. She wanted to die, right?
Yeah.
So on Wednesday morning,
she asked me not to call anybody.
she's pretty bad off. Wednesday
She
morning.
wasn't looking good. She couldn't. No motor control.
Did you call the rescue squad that Wednesday? She was bad off enough to where she should have called the rescue squad, but she didn't want you to.
She didn't want me to. Well, right, I should have. In hindsight, I know that.
So you didn't do anything to aid her death, but you didn't do anything to stop her from dying.
I really didn't. I mean, I just watched it happen.
Are you up to looking at some pictures of her? I can grab them real quick. Okay. Show you with the position she was in there. Okay, maybe you could explain it a little bit further.
I've got the image in my mind.
Okay. It'll take me just a minute. Okay. Let me bring back in the photos and I'll show you. See, like, here's a picture of Julie. And you can see here, look at the nose, how it's bent, like it was pushed into the pillow, like somebody pushed it in there. I don't know how to explain that, Mark. You know, here's probably a better. I mean, that's almost looks like it's broken. I have Dr. Chambliss's report right here, which says it's basically an asphyxia death. She's suffocated. And the only way you can suffocate, Mark, is if you did something to her. A 41-year-old young female does just not stop breathing. You had to do something, Mark. Be honest with me. Be straight with me, Mark. Be a man. Tell me what happened here.
Nothing more than what I told you.
You didn't get on top of her?
No.
Well, the evidence suggests is that there was a pillow over her head. But if you recall, you saw the nose, same as I did. I got pictures of it. Okay? You saw the nose and put a pillow over her head.
No.
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 Mark, how did she stop breathing, Mark? Be straight with me. Be honest.
When I found her,
Mark, you had to do something.
I did not.
How can I explain this?
I don't know.
I don't know. Well, let's get back here to Julie. I mean, here, we'll look at where you're sitting from my position here, Mark. Okay? One, we have a marriage that was not good. Okay? That was not good. You basically has a girlfriend at this point, the one that you were seeing before Julie. Okay? I've talked to some of Julie's friends, and they said she was divorced, was mentioned, some of this other stuff. You guys were not having a good marriage. Okay? You know, she contacts us a couple days before, and she leaves us this letter. Okay? Then all of a sudden, boom, she turns up dead. You know, I'm not making this up. This is true evidence. And here we have Julie Jensen telling me that if she dies, you're the person that did it. If anything happens to me, he would be my first suspect. I know he's never forgiven me for the brief affair I had with that creep 7 years ago. I have been doing this 15 years, Mark, and I've never had anybody leave me a letter telling me that if they die, it's this person that killed me.
All right, so that was a little bit of the interrogation that originally happened. There is a... So this was a little weird, this video clip that we'll play here. So this is what this is. This is the defense reading a letter to the judge regarding it's a letter from Jensen's sons. It's kind of a weird letter. Take a listen to this.
And this is from David and Douglas Jensen. David is here in the courtroom. Dear Judge Schrader, our names are David and Douglas Jensen. We are the sons of Mark and Julie Jensen. Throughout this case, we have remained silent, and the true character of our father has remained obscured. We write this to give voice to the type of man he is. After the death of our birth mother, Julie, he took care of us. We were, all of us, devastated at her loss. And the memory of him crying while holding his sons on his lap is one of my most vivid. He was there to comfort us, to make sure we were okay, not just emotionally, but in our daily lives as well. Our dad has been described as unemotional, or something to that effect, in the media. To those who don't know him, this may appear to be true, but in reality, he is a strong-willed person. He taught us how to hold ourselves up and carry on in our life, despite any adversity or hardship we may be facing. He never failed to support us throughout this ordeal. When he couldn't return to his work after he was charged, he started a business to provide for his family. It is true he worked a lot. However, this isn't uncommon with today's families. Despite this, he always made time for us. He has always done this for us. If we ever need help, advice, or just someone to talk to, we know we can go to him for anything. Also, whenever we spent time together, he made sure it was fun. Whether it was a weekend outing or just bringing home a Kringle for breakfast on Saturday, we enjoy the time we spend together. He cares deeply for his family. Even while being held in the Kenosha pretrial facility or Elkhorn during the trial, whenever we spoke with him on the phone, his greatest concern was the well-being of his family. If anyone in this world is the epitome of loyalty, it is our dad. He encouraged us to follow our interests and to do well in school. It didn't matter whether we needed some help on homework or just wanted to tell someone about an interesting article or book we'd read. He'd stop to listen and have a conversation. Even in the face of this case, our dad has been someone my family has counted on. While our desire would be for his immediate release, we realize the impossibility of this, as the court must pass a sentence in spite of his innocence. In light of this, we request that our dad be eligible for parole as soon as possible. We love you, Dad. Thank you. Sincerely, David Jensen, Douglas Jensen.
Thank you.
All right, so that was a letter written by the sons. It's kind of a weird, I don't know. It was kind of a weird letter, I thought. All right. Yeah, if you guys are just tuning in, the jury selection is not going to be live streamed for this trial. It's a little odd for Wisconsin to not do that. Opening statements are expected to start Wednesday morning, so we will be live for that. If for whatever reason they do go live tomorrow morning, we'll be live. So this morning, we're just playing some background info to kind of catch you guys up to speed. For those of you that are not familiar with this case, we were live anyway because we thought this was going to be live. If you're watching on Facebook, be sure to like and follow the page. Watching on YouTube, be sure to subscribe to the channel. All right, so we'll go through a little bit of background here, and then we'll play the sentencing of Mark Jensen from the original trial. So this is kind of interesting. So there's a website that I found. I can't tell like who this was actually set up by, if this was legitimately his like legal defense and whatever. But it's Mark Jensen legaldefense.com. So you guys can kind of go here and check this out for yourselves. There's a lot of stuff up here. So this one tab, letter examination. So this kind of talks about the letter. So Ron Kosman or Detective Ratsburg, it kind of dissects the letter, right? So Ron Kosman, should this not have been Officer Ron Kosman? Officer Kosman testified she was a friend and Julie was on a first-name basis with him. After she had 50 inappropriate contacts with Kosman, calling him instead of the Pleasant Prairie Police Department, the chief of police told Julie to cease calling him and that Detective Ratsburg would be her contact. Officer Kosman continued to see her inappropriately and defying the chief's instructions. the statement from the letter. I took this picture and am writing this on Saturday, 11/21/98 at 7 a.m. This list was in my husband's business daily planner, not meant for me to see. Julie put the Post-it note in Mark's planner on a random page and took the picture in retaliation for Mark's confronting her with what he had found in her dry bar as listed on the Post-it note. Her writing, I don't know what it means. It's an inventory of her dry bar that was in the bedroom and she kept locked. Her statement, but if anything happens to me, he would be my first suspect. Our relationship has deteriorated to the polite superficial. Ever since I told him last summer that I did not want a relationship with him any longer, I only wanted him to work and bring home the money. This was evidenced in email to Kelly on 10/16/98. On 10/15, Mark had another conversation with Julie in which she again stated she did not want a relationship. I asked the questions, heard the answers. We are just hanging out until one of us makes a decision. Kelly testified regarding that conversation of Mark's with Julie about hers and Mark's relationship that did not go well. The statement, I know he's never forgiven me for the brief affair. Not brief at all. She was planning a divorce and had compiled an accounting of how much money she would receive in a divorce settlement. The statement I had with that creep 7 years ago, Mark lives for work and the kids. He's an avid surfer of the internet. What does this last statement mean? Is she trying to set Mark up for something? There are two very dissimilar thoughts in one sentence here. Anyway, I do not smoke or drink. Then why did she keep a bottle of booze, vodka in her locked dry bar? And what does this have to do with anything about her fear? Her statement, my mother was an alcoholic, so I limit my drinking to 1 or 2 a week. Then why the locked up bottle of booze? Secret alcoholic, ? Vodka doesn't leave a liquor smell on her breath. She just contradicted her statement. I do not smoke or drink. So, again, I don't know who set this fucking website up, but something that we found. Mark wants me to drink more with him in the evenings. I don't. I would never take my life because of my kids. Why is she even mentioning this? It doesn't fit with the rest of the letter. They are everything to me. She would not commit unaliving, but she would fake an attempted murder to get the children and money and have Mark in prison for attempted murder. I regularly take Tylenol. She bought Tylenol in 500 tablet bottles, and multivitamins. Occasionally take over-the-counter stuff for colds, Zantac or Imodium. Then why the, I don't know what the fuck this is, nitrotrol, NS, a nasal spray, the empty generic Librium capsules. Was she snorting Librium? The Benadryl shells are empty Benadryl capsules. Was she also snorting Benadryl? Remember, she had Librium and Benadryl in her stomach contents at death. Have one prescription for migraine tablets, which Mark uses more than I. She was calling in for prescriptions for Mark, but the prescriptions were for her. I pray I'm wrong and nothing happens, but I am suspicious of Mark's suspicious behaviors and fear for my early demise. However, I will not leave David and Douglas. So those are the kids' names that were redacted from the actual letter. Why would she need to leave David and Douglas? She had been offered 4 times to go to a shelter with them or go to a provided home with them, not without them. She did not accept any offer to leave the home with the children because she did not fear she would be murdered. She knew she was going to take an attempted murder and accuse Mark. I don't know. So this, I don't know, this is dissecting the letter. Once again, here's a copy of the letter. We do have the letter on our Facebook page. Kind of interesting. So this next tab, who was she? So Julie came from a family that had a history of depression. Her mother suffered from depression, as did her brother, Patrick, who attempted unaliving at the age of 17 by slitting his wrist in the bathtub. He was found by his family in the bloody bathtub and rescued. I kind of find this hard to believe that this might be like the attorneys setting this up, right? This is a little too fucking graphic for, legal counsel. I don't know who set this up. I don't know what the fuck this is. But something that's out there. It's interesting. Let's see. Her mother was also an alcoholic. Julie substituted as a replacement mother during her mother's reoccurring drunkenness and her mental incapacity from depression. Her mother kicked her 5-year-old son, Richie, in the stomach in the morning, and he died in the afternoon. When the police arrived, the mother blamed his brothers for Richie's death by claiming his brothers had piled on Richie in a playful monkey pile in the backyard. It wasn't until the 4 brothers became older that they realized their mother had killed little Richie, not them. Mark and Julie had a wedding rehearsal dinner for 40 guests at a restaurant. Her mother did not have an alcoholic beverage for 3 days prior to the dinner in an attempt to be sober for the wedding. At the dinner, she suddenly stiffened up, slipped off her chair, and fell unconscious under the table. The rescue squad was called, and she was taken to the hospital, where she remained for 30 days, tied in restraints while she was recovering from alcoholism. She missed the wedding. After Julie's mother and father retired to Florida, her mother drowned in their swimming pool while she was drinking. Julie's brothers were heard to say that they thought their father may have drowned his wife because they thought she had it coming. Julie had 3 major clinically diagnosed episodes of depression, plus others during her relationship with Mark. I don't know. It's a pretty gruesome history. I don't know. Comment what you guys think so far. Again, I don't know who wrote this. I don't know where this came from. It's labeled Mark Jensen LegalDefense.com. This is a very old website. I mean, you can tell this was definitely built in the 90s, late 90s, early 2000s. Let's see, what was she up to? So Julie's letter saying, "In case I meet my demise, look to my husband," is a premeditated fraud. She crafted the letter over time and wrote it calmly and carefully, choosing her words with deliberation, and she crafted it in advance of the day she gave it to her next-door neighbor. The letter is not a rough draft or a note. Instead, it has a polished, edited, literary quality to it, evidencing its premeditated crafting. I kind of felt the same thing, man. Reading that letter, not to say she wasn't legitimately worried or whatever. It just seemed weird, certain things that she specifically pointed out in the letter. I don't know. Seemed a little awkward. Like this says, it almost did seem slightly premeditated, but I don't know. Who knows? It does not ring out as read as an excited utterance such as "my husband is going to murder me" or "my God, my husband is going to kill me." It is not a dying declaration. It is instead a smooth, premeditated written brief, almost a legal argument of many subjects to convince the police that Mark had attempted to murder her. Julie did not commit unaliving. She attempted to convince the police by her letter that her husband, Mark, had poisoned her. She ingested antifreeze herself and intended to call 911 and be revived, and her husband would be tried and convicted of attempted murder. Julie's letter is a fraudulent document. Its intent was to incriminate Mark Jensen, cause him to be charged for attempted murder. Julie would then get the children, the house, the bank accounts, the securities, and pension of her husband rather than only half from a divorce. She did not choose a divorce because she did not think she would get the children because of her hallucination, depression, and mental disability. Julie had been collecting prescription medications and over-the-counter medications for years in an off and on again depression, derangement of choosing an acceptable means of poisoning herself, not harming herself, surviving her experience, and telling the police her husband had poisoned her. She told select people she thought her husband was going to kill her, and she gave a letter to that effect to her next door neighbor so that she could create false evidence against her husband. The police removed 2 plastic garbage bags of medicines from the home after her death. All had been obtained by Julie through prescription or over-the-counter purchase and paid for I don't know what the fuck that means. Oh, from her checking account. There's kind of a spelling error here. Paid for from her checking account and hidden by her under lock and key. In the months prior to Julie's death, she was experiencing a major bout of depression from September through December. The kids were away from her at school during the day. She needed them as an emotional crutch, and she was mentally crashing. She was anorexic, had lost 15 pounds, 8% of her body weight, crying and distraught. She took Tylenol by the handful, Benadryl, antifreeze, plus other medicines and drugs. She couldn't sleep for 3 days. She went to see Dr. Borman, who prescribed Paxil, an antidepressant, and Ambien, a sleeping pill. Julie was mentally, physically, and emotionally crashing. She ingested these things herself and lost mental control of the effect of what her condition was, so she died. This is called death by misadventure. The police relied on her letter to charge Mark. The Wisconsin Supreme Court ruled that the letter could be admissible in court if the lower court ruled that the preponderance of evidence showed that Mark killed his wife. The lower court allowed the letter in violation of the Sixth Amendment of the U.S. Constitution, which states that evidence which cannot be cross-examined cannot be submitted in court. There was no preponderance of evidence against Mark in this trial, no smoking gun, no witness, no evidence. He gave his wife a dose of antifreeze, just the fraudulent letter of Julie's. So I think that part's, I don't know, a little misleading. I think from the original trial, I think there was definitely some pretty damning evidence. So again, if you guys are just tuning in, we found a website. I don't know who made this website. It's called markjensenlegaldefense.com. This is obviously very one-sided, so we're not reading this as like fact of this is what happened and whatever. But it does give a bit of background, a little bit of history. There is some factual stuff that is in here. All right, let's see. History of Julie Jensen's death. The story of Mark Jensen is very simple and yet very complicated. Facts are as follows. December 3rd, 1998, Julie Jensen, age 40, died, leaving her husband Mark and sons David and Douglas. Unknown to Mark and other family and friends, Julie had been telling certain select people that she feared Mark was trying to kill her. She targeted David's third-grade teacher, Therese DeFazio, her next-door neighbor, Thaddeus, we don't know how to say the guy's last name, and Pleasant Prairie Police Department officer Ron Kosman. She also planted other conflicting information about Mark. On November 21st, 1998, approximately 10 days before her death, she gave neighbor Thaddeus a sealed letter telling him to give it to police if anything should happen to her. Unknown to everyone but the targeted people, the police were considering Julie's death a murder. The targeted people had all been interviewed by the police within the week after Julie's death, and Julie's letter had been read. On April 21st, 1999, Mark had an interview with the Pleasant Prairie Police Department in which they were going to finally tell him the cause of Julie's death. Instead, Mark was subjected to a 7-hour interrogation. It was at this interrogation that he learned of Julie's letter, which was to become a pivotal point in this case. Mark retained an attorney. Nothing more happened until March 2002. So this kind of explains like why things, how many years had gone by when Mark was arrested. So she died in 98. He wasn't actually arrested until 2002. The trial kept being delayed until 2004, when finally the judge decided not to allow Julie's letter to be used as evidence in the trial, instead calling it a poison pen letter. So the next section is the timing of Julie's letter. It says Julie gave her letter to Thaddeus approximately 10 days before she died. It was the final draft of a premeditated letter that she had been crafting for a long time, as was her long-time accumulation of prescription medications and over-the-counter medicines. The letter could have taken as long to write and rewrite as it took her to collect the 2 plastic garbage bags of drugs and medicines the police removed from the house. Her collection of the drugs and medicines took years to accumulate. This part definitely sounds a little far-fetched, huh? And the letter could have taken months to years for her to formulate. I don't know. It kind of lost me on that part, right? What do you guys think? Did you just get lost in that paragraph? Kind of makes the rest of this sound like maybe it's a bunch of bullshit, right? Julie wrote that document to help incriminate Mark in her accusation of Mark attempting to murder her. She did not intend to commit unaliving. Again, we got to be careful with verbiage here. She did not intend to die, nor did Mark murder her. She was trying to accuse her husband of attempted murder and get rid of him. That way, instead of divorcing him when she would only get half of the assets and possibly not get the children because of her depression. In her severe bout of depression, anorexia, and insomnia, and with a stomach containing self-administered antifreeze, Paxil, Ambien, and Benadryl, plus other concentrations of things the prosecution toxicologist did not analyze, which kind of sounded like they did, though, right? She died through her own misadventure. She lost control of events she set in motion and died. Her intention was to call 911 and say to the paramedics that the husband had poisoned her, get him put in prison for attempted murder, and then get the children and all the assets. She did not think she would get the children in a divorce because of her history of depression and documented hallucinations. She absolutely needed the children as an emotional crutch, and her well-being was dependent on the children being with her as continuously as possible. As David was growing older and wanted to be with his friends more and more independent from his mother, Julie targeted a tic that David had during first grade, second grade, and now in third grade. She began a series of doctor visits designed to create a diagnosis whereby David would be medicated for the tics. Julie had been giving David such emotional problems that he developed the tic. Mark had taken David on a fishing trip to Lake Erie and noticed that David's tic stopped when he was away from his mother and began again when he came home to his mother. Mark then refused to allow any more of these doctor visits designed to medicate David for the tics. Julie was abusing the children for her own emotional needs. I don't know. This is all pretty bizarre. What do you guys think? Leave a comment. What do you guys think so far? Let's see. Legal issues surrounding Julie's letter. So just prior to the judge's decision, the U.S. Supreme Court made a decision in the case of Crawford v. Washington, which changed the hearsay evidence law. Previous hearsay rules of Ohio v. Roberts had been the standard. They were found by the U.S. Supreme Court to be arbitrary and subject to judicial discretion, with the judge deciding how they were applied, and this was unpredictable. They allowed out-of-court statements to be heard on a reliability finding and admitted core testimonial statements the confrontation clause meant to exclude. So this is kind of giving you guys a little history on hearsay, why like the letter was originally used, and then why the Supreme Court decided it can't be, because obviously hearsay rules changed. Let's see. Then there was Crawford in 2004, which changed the hearsay law and held that core testimonial statements needed to be tested by confrontation or they would not be allowed. Core testimonial statements were the primary target of the confrontation clause. There's a procedural guarantee that you had the right to confront your accuser. Julie's letter is core testimonial and should not have been admitted in court. The Wisconsin Supreme Court was asked by the Attorney General to rule whether Julie's letter would be admissible in court. The Sixth Amendment of the U.S. Constitution states that evidence is not admissible if it cannot be cross-examined. Julie was dead, so she could not be cross-examined. It's weird, though. We've seen, like, other murder trials, right, where, there's not even a body, right? They can't even find a body, and people are convicted. So I don't know. It's a weird thing. Wisconsin Supreme Court, to circumvent the Constitution, ruled new state law that said the lower court judge should hold a hearing to determine if the defendant had killed his wife and made it impossible for Julie to be cross-examined, which he did in August 2007. If the judge determined by the preponderance of evidence that Mark had killed Julie, the letter would be admissible. The judge in August 2007 ruled following the hearing that the letter was admissible because he believed Mark had killed Julie. This August 2007 hearing was a mini trial prior to the January 7, 2008 trial. Mark went into the January trial with the judge already having determined that Mark was guilty of murder. The judge, so they're talking about traitor, the judge therefore had a bias and allowed the prosecution to do so and say things that caused the defense to ask for a mistrial over 17 times. That's interesting. The states did not like Crawford because they liked being able to admit evidence that could not be challenged because it made it easier to convict people. So the states started adopting a broad expansion of the forfeiture doctrine by eliminating the historical intent to prevent testimony test. Now they could claim forfeiture and, in doing so, ignore whether the evidence was testimonial at all, since they had found somebody to have forfeited the right to confront and did so through judicial discretion in a forfeiture finding. This resulted in a broad expansion of what statements came in above and beyond what was originally intended by the hearsay rules of Ohio v. Roberts. Once you find forfeiture, everything is allowable. This forfeiture finding was what allowed Thaddeus to testify that Julie had told him that Mark's sister Laura had told Julie, "You don't know what he is capable of," while at the same time Laura was denying that she said it. The prosecutor was then attacking Laura as being a liar because it was not in agreement with what Thaddeus says Julie said, Laura said. That's fucking confusing. This is allowed under a finding of forfeiture, but never would have been allowed under hearsay laws. Laura was the alleged source, and denying it didn't stop it from being used. It's double hearsay with the author denying it ever being said, and it's allowed because forfeiture was found by a judge using judicial discretion, which is what the U.S. Supreme Court was trying to remove. Interesting. U.S. Supreme Court will be hearing the case of Giles v. California. The case will be argued on April 23rd. So this is obviously years ago, with final decision hopefully announced in the summer. So there's a lot more like ruling stuff. There's a few pages of this. There's a whole little, I'm not going to read this because I don't really give a fuck about Schrader, but there's like a whole thing about Judge Schrader. Some personal stuff in here. Why this case has national interest. The national interest this case has acquired is because of the violation of the Sixth Amendment of the U.S. Constitution, which states evidence which cannot be cross-examined cannot be admissible in court. There was no evidence produced that Mark killed his wife, no smoking gun, no witness, and therefore the letter should not have been introduced because the preponderance of evidence did not show that Mark killed Julie. State judges are attempting to circumvent the Constitution by saying if there is a preponderance of evidence showing the defendant caused the inability of the evidence to be cross-examined, and then the evidence can be introduced at trial. The state's changing of a federal constitutional law has opened a Pandora's box of legal mischief nationwide. Hence, national interest has been created with Wisconsin v. Jensen and California v. Giles, a similar case. National interest in this case is based on the legal issues, especially within the legal community. Woof. A lot of boring read. So you guys can go read that if you want. Again, the website is called Mark Jensen LegalDefense.com. You guys can read that. There's some stuff we didn't read. I'm going to play one more clip. So this is the sentencing of Mark Jensen. Let me just find this clip. So we'll play this and then I'm going to end the live. Again, if for whatever reason they do go live tomorrow, we'll go live. Otherwise, plan on Wednesday morning for us to go live for opening statements. Let me just find this. All right, bear with me here. Okay, so this is the original sentencing. So we'll play this, and then I'm going to jump off stream here. And again, plan on us going live Wednesday morning.
Of people to prison. I have sentenced scores of people to prison for murder. And when I assess the entire mountain of facts and evidence that exist in this case, I come to the conclusion that if I were to impose anything less than the maximum sentence in this case, I'd feel I had cheated the other people, because your crime is so enormous, so monstrous, so unspeakably cruel that it overcomes all other considerations. And Mr. Albee has correctly stated that there are plenty of positive factors in your background, and indeed the Supreme Court instructs us to consider a large number of factors in imposing sentence, but it is certainly the case that some crimes just are so enormous that they overcome any of the positive factors, and this ghastly crime is one of them. It's so saturated with malice, and I mean such long-standing malice. The persistent tormenting, torturing of this woman during many years, and then when this affair started, that you contemplated and planned and plotted this cruel method of execution for so long a period of time. The wickedness and cruelty of the manner of death that you elected in this case just speak to the content of your character. There are a limited number of people who would do something like that, and those people are people that we need to remove from society to protect other people, to make an example of people who would do things like this, and ultimately to affirm the dignity of Julie Jensen's life. That's why you're here today. That's why we as a society collect to deal with transgressions like this. And I repeat that I would feel when I compare the acts of others, the people who get into a barroom brawl and pull out a gun and shoot somebody and are sent to prison for life, against how you planned and executed this crime, that's not even a comparison. And as I say, I think I would have cheated them by sentencing them to prison for life if I don't impose the maximum sentence in your case. So unless there is some reason why sentence should not now be pronounced, I'll ask that you stand for sentence, please. Mr. Jensen, it is the sentence of the court that your custody be committed to the Department of Corrections for confinement in the Wisconsin state prisons without possibility of parole for the remainder of your life. You may be seated. You have rights to appeal with respect to the disposition of your case, and your attorney will review them with you. If you understand your rights, tell Mr. Albee he will have you sign a document acknowledging that. If you don't understand, tell him he'll bring you back in here for further instruction. There's a copy for you as well. Persons who are convicted of felony, as you have been, are ineligible to have firearms in their possession. That is a lifetime prohibition, and unless you have a permit from the Secretary of the Treasury, you may not have a firearm in your possession at any time for the duration of your life. It is a serious state and federal crime for you to do so. Mr. Albee will have you sign a document before you leave by which you acknowledge that you understand that it is unlawful for you to vote in any election held in this state until you, for the remainder of your life.
Since we started looking for a better cashback credit card.
All right, so that was the original sentencing of Jensen from the original trial. So that's gonna kind of conclude what we're doing today. Again, we thought the jury voir dire was going to be live streamed. Apparently, in this case, it's not. Opening statements expected for Wednesday morning, so count on us to be live for that. It'll definitely be live streamed. Should they go live tomorrow morning, we'll go live. But yeah, so we just kind of covered some background of the case. This should kind of catch you guys up on a lot of the details. Be sure to check out our Facebook page, NSM News Updates. We posted a copy of the letter. We posted a copy of the original criminal complaint. In this live stream, we went through a lot of the pretrial hearing, one of the last hearings that was done, to kind of catch you up on how, certain things are going to be handled during this trial, evidence that's coming in, evidence that's not coming in, some controversy that has been going on, and then kind of filled you in on a bit of background. So hopefully that catches you guys up, gets you up to speed, and an understanding of what the hell this box of crazy trial is going to be. And we'll see you guys definitely Wednesday morning for day one opening statements of the Mark Jensen murder trial. Thanks for tuning in, and we'll catch you guys.